1 minute. Which case you read, Mr.?
Wait.
Recently?
Finally, party came on record.
13%.
Came on record. No, it's 91.
Why this 23 matter has come up for hearing?
21.
The 23 petition.
Item number 91.
91. This 23 petition. Why?
No, 1 second.
I came on because
This final hearing list is not with me, madam. See, the copy we given to me doesn't have the final hearing list.
The list what His Lordship is having is different from what I have. This is our website. This regular.
This is up to 93, right? Cases.
The final hearing.
How many cases motion hearing are listed, Mr.?
Motion hearing 87.
See this list. 87.
87.
So then hearing is 88, 89, 90.
No,
Who is listing this for hearing 23 matters above this thing? I had told that it has to be in chronological sequence. How these cases, who has listed this? You explain. 23 petitions from 88, 89, 90, all these 23 petitions, who has listed? Whether our order, whether what at the order at the top of the list, how you are doing this? This senior counsel aged about 80 years is waiting for his 2005 LPA. And this 233 matters are being heard.
this list is wrong. That is the translation of what is happening.
See this and see what, how do you explain the discrepancy between his lordship's list and my list?
No, but this is final hearing some 2021 matter.
Final hearing C88 number. No, see. What is it in this list? Which year? And thereafter? 88, my list. Is it different or not? Mr. Reddy? What is this? How these 2023 cases you have to submit a report by 1:30. Madam, how 2023 cases are at the top of the list? This thing leaving behind 2002 and LPA of the year 2000. Got it, madam? Please, along with Mr. Reddy, you come at 1:30. Not done, Mr. Reddy. Yes. Yes. So what? 91. 2020. Who appears for the appellant?
My lord, I am appearing for 91. Item number
91. You are for the appellant petitioner. Who is somebody saying adjournment? Who is government advocate? Who requested for adjournment?
Appearing.
Nobody is requesting that.
No, he is requesting.
You are requesting for it.
I am requesting.
Who has filed? Acha, there is a this thing, Mr. Stay in your case. Interim order. No interim order. All right.
You are appearing, Mr. Additional Advocate General.
See, Mr. Is there any interim
I am
order?
appearing for assembly, my letter for the.
So what is the urgency in seeking an adjournment in final hearing at 10:30? No, you go recently also. Today you go, you came recently, go recently also. How are we concerned? What we are trying to emphasize, there is no urgency in seeking adjournment at 10:30. We should perhaps begin our day by hearing some case. No inconvenience. It will be called. When it will be called, you make a mention. No adjournment at 10:30. Yes. No, nothing. No 90. Motion is over. It's all not time to seek adjournment. Yes.
Item number.
Nothing happens, Sarpanch. What is happening? Your election has been declared void. Huh? No, no, what is it?
It's 3 days on the report on the other side because
Report?
waiting for my appeal time.
We heard one Sarpanch election, that is being removed now.
That what is that?
File a petition.
While it's May of that's the second that has been considered by
No, we will give it that, give it to.
What happens, Sarpanch? I mean,
4 months is left over.
that we have decided, right? Your case, we heard you. You are the same Sarpanch, right? Who filled in the declaration form incorrectly, left blank everything, and was arguing that this stipulation that we remember.
Yeah, yes, admitted of
Ah,
considered. And so that was not even informed.
No, he's already been new person as even on that day,
so you want rejection today itself, Mr. Call it.
even
Ah.
on that day,
We
they
had
taken over. They have taken over.
No,
The
no, we
new person has-
inadvertently we did not say that his stay petition is rejected. So we will reject it tomorrow. Fine, give it. Today itself you want? No, no, today. Why? But you tell the other side. Huh? We gave instant justice, right? One mentioning like, so you tell us when they have taken over. What is WP number, your WP number? Get the file,
Return number 783 of
783. Of,
323.
what is the stay you are seeking?
That is
What is the stay you are seeking?
suspend the order appointing people of the other was fixed as monitor as
Suspend the order dated.
dated.
Tell us, instant you should be ready, right? We are doing it just now. Yes. Is order dated? What? Please. Please. You find out till the time we take up other thing, you find out when the order dated so and so appointing R6 as Sarpanch. Right? And when the order was passed by learned single judge and when we passed an order admitting your appeal. Yes, madam. The PIL nothing to lose, mister. You don't. So, what were you doing? There must be some office objections. Office objections.
No, no,
That's
is
why
it
it is not.
numbered? Is it numbered?
Why?
There must be some office
How
objection.
say so? Public interest doesn't mean that you can do anything.
There must be some office objection asking you to explain how it's in the public interest or something. Please check up.
You are a liquor contractor, right? Friend of a liquor contractor. Friend of a liquor contractor, right? You want this. What is this? All sponsored, Mr. Saturday. Saturday. No, first comply with office objections first. Comply with and then make a mention.
Then make it.
Find out this. We can't list it for this thing. 9th of August, you should have thought that why it is not listed. Find out and then make a mention tomorrow. After complying with office objection, we will grant it. Just like him today itself. He is mentioning today itself we are passing, he has run away. Like that. Yes. What will?
There's a significant contempt of things which are connected of the year 2020. The respondent, that is the government, have taken the interim suspension orders way back in 20.
You have filed vacation. IA. Monday. Saturday.
No, Monday is to work.
Then 23/8 for consideration of vacation of stay. IA. Not hearing. Yes, madam. Vacate stay petition is pending. List on
Same day.
23/8 for consideration of vacate stay petition.
You have mentioned the IA number, madam.
Yes,
You have mentioned the
IA number.
IA number. Mention the IA number. We will only
Yeah.
list them under interlocutory.
Item 116, 117, and 119, your lordship.
No urgency in seeking adjournment.
I'm not. sitting at
You
the-
want to withdraw?
No, no, no.
Then
I'm requesting matters may be taken up, your lordship, if at all they don't reach your lordships today. The reason
we will see that.
They are in the final hearing.
Final
caption.
hearing list. Yes.
When the matter comes.
A 2:30 later part of the day.
2023 matter.
Your lordships, that is the reason. Subject permits.
Yes.
You can mention a little later, Mr. Mention a little later.
Obliged, lordship, obliged. Subject permits.
Yes.
Subject permits, Lordship. Commercial courts appeal pending before this honorable court, Your Lordship. We are the respondents in the appeal. We
Vacate
filed
petition.
modification petition, leave petition.
Modification.
Yes,
IA number given
yes, already mentioned.
23-8.
23.
Please, your lordship,
Tomorrow, small matter tomorrow.
23rd.
Obliged.
your lordship's permission, writ appeal 116 of 2013. It was,
Which IA is pending?
your lordship,
Which IA is pending?
I
in
is
that
not
appeal?
pending, your lordship,
You want final hearing?
not finally hearing,
Then
at least from.
you want to
writ
withdraw?
appeal 2000, not
You want to
withdraw.
withdraw the appeal? Then
Government has gone for appeal. In writ petition, we have,
You have succeeded in.
we have succeeded in the
so what do
petition.
you want, Mr.?
No, third party encroachers, third parties are encroaching into our plots, your lordship. Kindly it may be taken into next.
One second, if third party, some developments are taking place, you need to place it on record by way of an affidavit by filing an IA.
Have you filed an IA? Nothing. Then yes, it can't be heard because somebody is encroaching.
Your verbal, the statement,
At least we have not.
Next,
Public interest litigation, your lordship.
Huh?
Filed it on 480.
all youngsters are dedicated to the public cause, right? Huh? Now what? No, what is it about?
It is about.
4th August you have filed. Why it has not come up? Office objections. Please comply today.
Complied, your lordship. We're also
Then it will come up tomorrow, Mr. If it is so.
which might take it up.
What is the urgency? Is it numbered? What is the urgency?
SR.
SR number means it is not yet numbered.
Go and this thing, meet the registrar judicial to find out how, why it is not listed. Because our rule says that if it is a numbered, next day it comes up. That's a mystery to us. That 4-8, you are relaxing. What is public interest?
GST authorities are not implementing the GST laws, your lordship. But
Ah.
laws to the extent.
The police authorities are not implementing provisions of IPC and CRPC. It's like this. It's all frivolous, Mr. Frivolous. Vague and frivolous. You come ready when it comes up for hearing on the question of maintainability of PIL at your instance and say that all those persons who are aggrieved by non-implementation of GST laws are so poor and so illiterate that they cannot approach the court. Therefore, I am approaching on their behalf. Say so. And be ready to pay. We will hear you, of course, be putting you to notice that be ready to pay costs also for filing frivolous litigations before this court. Kishore Samrite, Supreme Court has said. Yes.
I apologize, Lord.
We are putting you on notice. Be come ready. Don't come like with the file and then we ask questions. Then you say, I don't know.
I apologize, Lord. I have mentioned in the list, may I make it public?
Huh?
I have mentioned in the list numbers.
That is over.
Much obliged.
It can't go on for an indefinite period. Yes. Yes.
Right period. Appellant is the petitioner. Matter under the Land Acquisition Act.
Person to. Which part of you the petition more than the same thing, but
In that case, we will be relegated because there were no similar persons for whom compensation was paid under 20 years. Slightly different point. Yes. Who appears for respondent?
Lordship, I am permitted to represent
Everybody-
on behalf of Avani Reddy of Lordship.
No, everybody appears represented. Yes. Yes, Mr.
Well, it's
Appellant. You are not saying anything, right?
That's 28A.
So we will say that you don't have to say anything and we will pass an order. No, we will take this, Mr. Once you should realize.
28.
Heard on IA 1 of 2023, an application seeking, mark their presence seeking condonation of delay of
86 days.
86 days in filing the appeal. accordingly delaying filing the Judge bench, 9 judge bench.
But-
There's no full bench.
But Bharat Singh judgment merits have passed on merits.
Which paragraph? Which judgment?
Merit, this has
Which
been
para?
merits. Para 14 merits. Merits para 10 merits. The judgment which I am relying upon has been relied upon. Para 10 merits.
Pradeep Kumar.
Pradeep Kumari ji.
Respondents 5 to 10 minutes by BC. Mr. So this is an authority for the proposition that successive applications under section 28A are not maintainable.
Yes.
So respondents 5 to 10, when they filed applications under 28A, give us the dates.
Merit.
What happened to first
First
application?
application was merits. First application was filed on 27/1/1990.
When the AS was pending,
By the time AS was pending.
that is what,
But-
that is what is the crux of the case.
But Millets, they have, we are not in appeal, Millets. The
No, other landowners were in appeal.
other landowners, we have accepted.
All
that.
right. So then say, what happened to this first application?
Millets, this was pursuant to this application, as per the reference court award, they were paid compensation.
No, what happened to this application?
This application was allowed, Millets,
When?
21/11/1994.
Then when did they file second application according to you?
Millets, this application is filed after the High Court has, Millets, on 2011/2014.
How, during pendency of this thing? Before passing of an order itself? By same respondents 5 to 10.
Yes, Millets.
You are getting what we are inquiring from you. This authority 2018-11 SCC 92
Yes.
at the best is an authority for the proposition that successive applications under this is the, according to us, the ratio.
Yes.
That two successive applications under 28A of the Act are not maintainable.
Yes.
And you are relying on this, you are telling us that first application was filed under 28(1) by respondents 5 to 10 on 27/1/98, which was allowed on 21/11/94.
Yes.
Even that application could be allowed, they filed another application
But that
on 20th/11/94.
Millets, the point I am trying to make, Millets, we
14. So then AS was decided when?
AS was pending on that day.
AS was decided when?
AS was decided.
6th December 2013, Millets.
No, the second round of AS.
The
First round of AS is AS number 978 of
that
1990.
is 20th February 2001.
So-
Come to page 4 of the order of the learned single judge. The details will be there.
Yes.
AS was pending on that day. Same issue, same facts are
Same.
similar.
Bharat Singh and the state of Maharashtra case of this case are similar, identical.
Millets, I'm
No.
relying on, Millets, this proposition.
No, we
we
want you to
accepted.
understand, sir, irrespective of the decision of the case, you should understand. What we are saying is that special and distinctive factual position in this case, as noticed in Bharat Singh in para 15, is exactly similar.
But this,
Got it. So you are relying on what judgment?
I am relying on another judgment, I have passed on 2009, 1 ACC 754. I have given book.
So this is considered, right?
No, this was not considered.
No, Pradeep Kumar was not considered.
Kendriya Karmachari Pradhan. That proposition would be applicable if I have not accepted, as a requisitioning authority, if I have not accepted the award and if I am in appeal. I have accepted it and I have paid the compensation as per that.
All right. Correct.
At para 7
That's-
of my grounds, I have
So this is you are relying on Union of India versus Pradeep Kumari.
no, apart from that, another judgment, at para 7 of the writ appeal grounds, I have.
Which judgment?
Citation.
Kendriya 2009 1 ACC 754 millets.
754. What's the citation?
That's Kendriya Karmachari.
Kendri Karmachari. What is it? Which para?
I have extracted the.
Tell us which para? Kendri Karmachari. Subordinate Delegated Legislation, CTC Section 10. Land Acquisition Act 28A.
This I am for the proposition that if I have not accepted, if I am in appeal before under section 18 or other appeal, then that proposition would be applicable. Since I have accepted the
What proposition would be?
the learned single
So
judge.
what is the ratio according to you of this decision? Why you are relying on this?
This I am relying since I have accepted the judgment and paid the compensation.
Accepted judgment of whom?
Section 18 reference court and paid the compensation under section 28A.
Accepted order of reference
Reference court
under section 18. Therefore,
and paid compensation under section 28 to the remaining similarly placed person.
Then
The judgment relied on by Bharat Singh Gulab Singh judgment would be applicable if I have.
Therefore, the judgment in Gulab Singh does not apply. Bharat Singh.
Does not apply.
Correct. So for that you need another case law.
No, but sir, another.
This judgment to say that how can in 2009, Bharat Singh is when 2018. Bharat Singh is 2018. How 2009 Supreme Court can say that judgment rendered in 2018 will not apply to case of such a such?
On facts,
Impossible.
On facts, I am trying to disagree.
That's why we asked you to understand for what proposition you are relying on this judgment. It can't be for the proposition that Bharat Singh judgment in 2018 does not apply. The Supreme Court cannot say so in 2009.
Well, it's one another ground.
9 years earlier.
Well, it's one another ground. Well, it's under section 28(3).
Understood.
28(a)(3), they could have filed application under section 28(a)(3).
All right.
Because if they have not agreed the compensation, they could have filed application under section 28(a)(3).
Yes.
16 is the answer for whatever you have said. Bharat Singh.
Right, but it's good that Mr. Harsha, you argued so well.
Well, it's
This is what we want. Yes,
well, it's
that's it.
Well, it's another.
Anything else?
Well, it's one another judgment. Well, it's.
Don't I mean one proposition, 13 judgments. Don't I mean we will not write one proposition, one judgment is
a very short judgment. Well, it's.
No, short or long, but you have already told us, right? What else?
No,
you must tell us
on the ground that for the point, well, it's that compensation enhanced in an appeal. Well, it's successive applications under section 28A is not maintainable.
That is what has already been held, right?
Well, it's very short.
This is in Bharat Singh itself, it has been held.
Well,
that's successive applications under 28A not maintainable.
Well, it's for paying 30,000. Well, it's the High Court has enhanced from 30,000 to 90,000.
Whatever.
But it's one parameter I will read.
No, you should thank that it's not under 2013 Act. And it is 1894 Act. So pay whatever, get away with it. You want to test it, go ahead. Yes, learn it. Very good, Mr. Harsha. Irrespective of the result, you have argued with clarity. and we must place on record our appreciation for this approach. But before handing over this, you should tell the proposition. Further scope for improvement is, for this proposition, I am referring to this judgment. That's what you should do from next time. Learned counsel for the appellant. Learned counsel for the appellant submitted that learned single judge ought to have appreciated that no successive applications under section 20
Item 5.
Five is also same.
AS numbers.
AS number that you will do. Thank you. Please give that list to me. My list. No list.
What is?
This list. This, yeah. Fine.
I can go and see the Coverage.
My lords, the application filed by us for extension of time fixed by the honorable.
So the honorable Supreme Court gave time. They did not find it within 30 days. So they have to seek extension from maybe the honorable Supreme Court.
My lords have adjourned the connected appeals to 6th September 2023
To enable-
and our application will be listed on 21st before the honorable Supreme Court.
Learned counsel for the petitioner submits that the application seeking extension of time
We have put the details. Without making any payment, madam, is hold up with the property by making it a small piece. And my lord, after that, my lord, when we refuse to connection, my lord, as per general terms and conditions of supply, my lord, they approve the, my lord, moral, where my lord, they cannot approve because they are not consumers under the act itself.
Ah,
They cannot approve. That was, my lord, it was rejected. Then they went to appeal, where is.
no. So see, mister, if they are not consumers, perhaps you cannot recover the electricity dues from them.
We are not recording, we are saying, my lord, we refusing to service connection.
Okay,
That's all.
all right. Yes. So what, mister, what do you say about delay?
Delay may be controlled.
Condoned. All right. Third learned counsel for respondents on IA number 1 of 23 and 2 of 20, 1 of 23. See, computer thing is not coming, right? Yes, condone, IA 1 is condonation, right? For the reasons assigned in the application duly supported by an affidavit, we find that sufficient was solve pro forma, 12 days made out, delay in filing appeal condoned, IA allowed. Learned counsel for the appellant submits that the learned single judge ought to have appreciated that respondent number 2 is not a consumer, and therefore the transpo, AP transpo, you are what? TS transpo. TS transpo could not be compelled to provide
Distribution.
TSS.
discom. Therefore,
DCL.
whatever. So and so discom could not have been compelled to provide electricity connection to the respondent,
Subsequent person.
to the to respondent number 2, who was the subsequent purchaser and not a consumer of the transpo. Full stop. In support of aforesaid submission, learned counsel for the appellant has placed reliance on decision of Supreme Court in KC Ninan versus Kerala State Electricity Board 2023 online SCC 663. In view of aforesaid submission, doesn't mean that I need to be heard on Sunday, so we will come here at 10:30. Doesn't mean that you are not, you are just like any other litigant for us, right? That doesn't mean that I will file by Friday. Therefore, at 9:30 PM, you should sit here and by 10:30 held him to ransom and see that by 10:31 electricity is supplied to your premises. This is no kind of attitude.
I leave it to
We have, there is a limit to everything. We have admitted it. The appeal, you have the right to file an application seeking early hearing, saying that nature of controversy, please hear this urgently.
I
That
apologize.
you can do.
I apologize.
Not like I will argue. Don't argue.
I
Don't
apologize.
argue on Monday. Who's telling that argue?
I apologize.
We have better things to do, right? Not the only providing electricity to your premises.
I apologize.
Don't say doesn't want to file. 2 weeks time to file counter to IA2 of 23. In the meanwhile, right? List after 2 weeks for consideration of IA. Don't say anything. Praise fund is granted. Meanwhile, that's it. Yes. So let's.
Like, see them for sure.
Every day he brings me this thing that is known as 55. Actually, he do like it. Seeking, we can make that towards public purpose. Yes. Yes, please.
I'm for the respond number 1.
Now the petitioner. Nobody is there for the petitioner.
May I please, your lordships, is this, I'm sorry, it was not audible. Is this item 6, my lords? I'm appearing for DSB law firms, my lords.
What? Yeah, yes, madam.
Yes, my lords. In this matter, my lord, actually there is a civil dispute pending
Ah.
before the appropriate civil court.
Ah.
Bypassing that, my lord, they have approached this honorable court by questioning this order dated 8/6/2023. In fact, this is in question before the honorable civil court in OS number 390 of 2023, in which the very identity of the land as well as the title is in question, like, because there is a civil dispute between the appellant and also the first respondent.
Speaking order.
Now this
The
order passed by the learned single judge, your lordships may kindly appreciate.
Yes, 1 minute, madam.
Okay.
It's. This is 8/6/23, the order, speaking order.
Shooting order issued by the.
By respondent to administration. 3. Directing what demolition, remove unauthorized construction belongs to the appellant.
Belongs to this actually.
The appellant.
He is the developer of this layout.
So this is not heard. Who is pending?
Where is he spending and
Who appears for the municipality?
I appear
So two grounds, madam. Order is dated violation of natural justice and was passed, and a civil suit is pending. Can you hear us, madam?
Yes, your lordships. My lords, actually civil suit is pending. Now the difficulty with us is, my lord, in fact, the municipality is not empowered or has any jurisdiction to issue such notice of speaking order, because the very dispute is between the appellant and the first respondent. So this has been deviated in this form. This is a self-declaratory speaking order which has been impugned in the writ petition.
All right. So you were not heard by the learned single judge, madam.
Yes, your lordships.
You were not heard.
Yes, we have not been put to the notice also.
What do you say, Mr.? How can they be not heard and then NOS is pending with regard to the this very land with regard to nature and extent? How can you defend the order passed by learned single?
May I say, Malad?
Oh, you want to defend? Yes.
Malad,
Please.
first of all, the civil suit as referred by them. I am not the party in that. The suit is filed against corporation. Basically, a complaint was given to
OS filed by the appellant against corporation.
page number 61, Malad.
Appellant against corporation to which rate petitioner is not a party.
Not party, Malad.
Yes, sir. Then
But the writ petition is filed questioning, Malad. First of all, a complaint was given, Malad, on 8/2/2023 at page 47.
Complaint was given. 8/2.
2023, page 47-48, Malad. Wherein, Malad, a complaint is given.
Page
47 and 48, Malad.
47, 48. Yes, then what happened?
In this complaint is mentioned, Malad, stated that the appellant before this court, Malad, had encroached on the roadside and made construction on the roadside on the land which is being gifted by the respondent number 1 year in.
This point is in.
One minute, madam, we will hear. On the road and constructed what?
tin shed.
Constructed a tin shed
Tin shed, Malad.
on the land gifted by you.
Road and develop charitable purpose.
Oh.
Yes, and a registered gift, Malad.
Land tin shed on the land gifted by petitioner.
I predict
Petitioner.
Yes.
Petitioner to which person? To whom you had gifted? Municipality.
Yes, Malad.
Yes.
For the purpose of development.
One second. Internal codes and everything.
They have to maintain it.
No, they have to execute a deep breathing of the
Same.
so that the roads and all rest with the government. But that doesn't mean that they become public property.
Yes.
But
Then
the writ petitioner has constructed villas and sold the villas to the private parties, Malad. He has kept the side portion.
Respondent or you?
Read petitioner. Read petitioner.
Petitioner. Sold villas.
Not
Yes, myself. And my lord, he has kept a front side portion for their purpose, which is having two entrances, road side and rear side. And that rear side, my lord, this encroachment has been done by raising RCC structure. Photographs also there, my lord.
Yes.
Thereafter, my lord, on my complaint, my lord, and was passed calling upon both the parties.
Past 8/6/20.
On 8/6/23, and speaking order was passed, my lord.
It's 8/6/23. Yes. What do you say that this order has been passed by learned single judge without hearing R4?
Page number 16 order is there, my lord. That is order is passed.
No, passed without hearing petitioner or by hearing appellant?
Yeah,
That's it.
yes, my lord. It was disposed of.
Without hearing the,
Giving direction to the corporation to give opportunity to both the parties.
But
1 minute.
Page number 16, my lord.
Without hearing the appellant, but order is innocuous. Huh?
Order is giving
No, innocuous, that opportunity of hearing.
giving opportunity.
So supposing if you would have been place of respondent number 4, you would have also advised your client to go to municipality and file objection instead of filing writ appeal, correct? Lighter vein, mister, you can at least smile.
Yes.
There is nothing serious.
I agree. I agree.
We are not sentencing
Yes,
anyone
yes,
to death by neck,
No.
hanging
Yes,
by neck just
Certainly.
now in the, don't be so serious.
No.
You can at least smile.
Correct,
Yes.
correct.
Yes. So, all right. So you say that the order is innocuous in nature because it gives an opportunity of hearing. There is no adjudication of rights.
Basing on which, my lord, corporation should notice giving opportunity to both the parties. And the appeal filed my objection.
Fine.
Instead of filing objection, the present appeal is filed.
Writ appeal. Okay. Yes. All right. That's it.
Well, it's Sayapur for municipality.
You don't have to do anything. That's why people come to us. Yes, madam. Yes, please.
may I please, your lordships, if I kindly peruse page 15, your lordships.
No, that's correct, madam. What did two questions to you? That, see, rightly or wrongly, an order dated 8/6/2023 has been passed against you by the municipality.
Yes,
Right. Or whatever notice or proceeding has been initiated. Notice. So it's only a notice. You did not challenge that notice anywhere or this thing. You are not, you are, just a minute. With notice dated, where it challenged, madam?
That is in OS 390, my lords. Because the very notice is.
390 of which year?
It is at paragraph 5 of my writ appeal.
No, 390 of 23.
Yes, your lordships. And while this was pending, but the other respondent.
What, is there any injunction?
No, my lords. For injunction, we have filed a application because here my humble submission is there is a dispute as to the identity of the land, first of all. So now this is a self-declaration. It has not really passed on. This is all they are saying. We were not heard. In fact, we have also filed an explanation which is at page 80 and 81. They are not.
So, madam, we can do one thing. See,
Yes.
you have filed a suit for declaration that this notice dated the 8/6/23 is null and void, and you have sought a permanent injunction.
Yes.
You have also filed an application for temporary injunction, which is already pending. And secondly, you have not been heard. Otherwise, if notice would have been given to you, you would have brought these facts to the notice of learned single judge.
Yes.
Now, what we can do is, Mr. You can intervene in that civil suit filed by the respondent number appellant herein, and we direct the trial court to decide an application for injunction in a time-bound manner. subject to outcome of your application for injunction, the municipality will proceed. If they High Court holds that no, they can't proceed, and this is null and void or grants an injunction, nothing survives. Right? Otherwise, if your application is rejected, something happens, they can proceed. Correct?
Very well.
That's it. Yes.
Correct. May I say one?
Correct, Mr.
There is no dispute that they are imposing on the roadside. They admit this fact.
This is to be decided in that proceeding. We can't in 226 hold that they have.
They admitted that fact.
They admitted. Good. Tell them before the civil court seek an impleadment saying that yes, madam, right. Mark the presence. Mark the presence. Heard on IA 1 of 23 dispatch. think that anything else can be done. What then? How do we expect them to decide civil suits if in injunction is the application? Then no, leave it to us. 2 weeks for a period of full stop. The needless to state that the municipality shall abide by the orders which may be passed by the competent courts. Till the application for a temporary injunction is decided, no action shall be taken in pursuance of speaking order dated 8/6/2023 passed by the municipality. Line below, to the aforesaid extent, order dated 24/7/2023 passed by the learned single judge is modified. Accordingly, the appeal is disposed of. Please. Heard on the question of admission. Petition is admitted for hearing. Notice. Everybody accepts.
Yes, I am sorry for fourth respondent.
Whosoever accepts, issue notice to remaining respondents. Mr. Local candidate, Mr. Rao, what happens to local candidate?
Tomorrow it's posted tomorrow.
List what along with WP number?
WP number 21.
Huh?
23160
23 23. Tomorrow is what? 18/8.
14 also same.
14 also same.
14 also same, Mr. Prabhakar. Same tomorrow.
14 also same order. Yes. 9
Same tomorrow.
tomorrow along with bunch. Yes. 9 NCC quota.
No, that is police.
Notice. This
This is the MBBS.
MBBS. We have
This is
entertained, right?
This is also tomorrow.
List along with WP number
18674 of 2023.
on which date? Tomorrow. What date? Tomorrow is what date? 18/8. Please write. 11 is same.
No, 1 second.
11.
Yes.
10.
Yes. I am the petitioner.
You are appearing for the
Petitioner.
petitioner.
Petition.
Why did you impede YSR University?
Already,
No, why is it?
they have also issued a GO.
You'll have to go to AP High Court. They are not within the jurisdiction of this court.
No.
What is the relief? Please see the relief. Please see the relief. What you have asked, and why have you made YSR University 8th respondent a party in this writ petition?
I have not seek any relief.
But
Then delete then.
delete. Why is it before this court?
Because
You go to Andhra Pradesh High Court then.
no, my lord. The Andhra Pradesh, the reservation is provided erstwhile undivided Andhra Pradesh, and the Andhra Pradesh Reorganization Act is.
We cannot grant any relief in respect of a university situated.
No. I am not seeking any relief.
Then why have you implemented them? Delete it.
The Andhra Pradesh government have also issued the GO.
No, you want us
referring
to.
the 85.
No, you want us to pass an order, or will you delete R8? We are inclined to admit your petition provided you delete R8 today, just now.
Okay.
Okay.
Delete.
Don't say okay. We are not in an informal conversation with each other.
No.
Right? Okay is not a word used in the court, right? Learned counsel for the petitioner undertakes to delete the respondent number 8 from the array of first title.
The admissions are closing by 19, my lord.
So,
19 by this month.
so no admission should be finalized according to you,
Yes.
interim relief.
Yes.
Huh? Why?
Web options are open. Today, web options are open.
The same matters are there, no?
Yes,
Same
yes.
100% reservation.
We have passed an interim order in those cases.
No, no.
No interim order. Other cases also no interim orders have been passed.
Earlier, this honorable court has.
Where is it? Give it to Mr. Prabhakar Rao. Tell us, you are not arguing next case is called, right? Huh? So much obsessed with respondent number 8 that unable to respond after its deletion, right? What is this, Mr.?
Those orders are relates to the competent authority quota, where 85% are reserved for local candidate. This is the management quota. Management quota, 50% in private college, 50% competent authority, 50% management quota.
This
But
is
management quota.
this is relates to
all India
management
quota
quota only.
or all India quota.
Any admission made. Heard on the question of interim relief, any admission made under the management quota shall be subject to outcome of the writ petition. And you appear, Mr. Rao.
Yes, yes.
Mr. Prabhakar Rao, Learned Counsel for University, and so, whosoever appears, pray for and are granted 4 weeks time to enable them to file counter. Then our right, any admission made shall be subject to outcome of this petition. Next.
May I please?
Yes,
But the petitioner
go ahead.
petitioner was appointed as junior accountant in June 5, which is Miladi, Telangana state. But he was appointed.
We are coming after 1.5 years. What is the justification? 2021 proceeding you are challenging now.
Miladi, after that, he made several representations till
Petition is admitted for hearing notice.
Miladi Valashme kindly Miladi consider.
Ah.
Our husband is.
No, you are not arguing anything. What will you consider? We told you to argue, and my lord has asked to 21 February 21. You are coming here. Give
For
it.
that, I give that.
In this petition, on the question of interim relief, the petitioner has challenged the order dated 1/12/21 after a period of 1 year and approximately 6 months, 1.5 years. Therefore, no case for grant of ad interim relief is made out.
Your last mail kindly consider, she made a representation. The second respondent recommended her case. Her Milad husband is working in Milad in state of Telangana. She is Milad was an employee of Zone 5. Order.
That's why we have admitted your petition. The question was only with regard to grant of stay. What have you done for 1 year and 6 months?
Milad 1 year.
So spend that more 1.5 years with them only.
Milad, allow me Milad
to this court.
to Milad bring to your lordship
We
notice.
don't want to damage you. Don't say the rejected notice.
Milad,
That's good
already
enough.
she suffered Milad. Your lordship kindly see. Otherwise, I won't request your lordship.
No, there's
She
no
made
question of,
representations.
there's no question of making a request. It is only a prayer is
Once
made to the
Milad
court.
come to a conclusion.
Prayer is
It
made.
is not appropriate on my part, Milad, to make anything. But this
Please.
case, Milad, kindly hear Milad.
No, we have not come to any conclusion. You are free to argue on interim relief.
Yes.
Answer the question why you have come after 1.5 years. Simple. My brother asked this
Milad,
question.
for
Answer.
that, my answer is, after that, I made a representation. The second respondent recommended my case. I made representations. All are pending. Milad, your lordship may at least direct the first respondent to consider my representations. Milad, your lordship may kindly see page number
Who is first respondent?
54. First respondent, Milad, Telangana Genco. Telangana Genco. I am born an employee of Telangana.
Representation. Learned counsel for the petitioner submits. Learned counsel for the petitioner submits that being aggrieved by your allocation to state of Andhra Pradesh, AP Genco.
not allocation. And I have got an employee of Zone 5. I was sent to deputation to AP. That's it.
Being aggrieved by rejection of request of the petitioner for repatriation of her services from AP Genco to TS Genco, the petitioner has submitted representations which are pending consideration. In view of aforesaid, learned counsel, write her name, who appears for TS Transco, submits that the representations submitted by the petitioner shall be decided. Paragraph, in view of aforesaid submission, we direct that the Transco shall whatever Telangana State Power Generation Corporation shall consider the representations which are submitted by the petitioner with regard to her grievance about the order dated 4 weeks,
Much of
if any be filed. Will be more than reasonable. Then these sort of disputes I have dealt with as a judge of Karnataka High Court division bench orders.
Yes.
And if I remember correctly, I don't have it right now, but what we have done is we have referred the candidates to the independent medical board which may be suggested by you, or state board of state government, whatever. And what has happened in this thing, just we are discussing that he will subject himself to the medical board. He will be examined by the experts, and supposing if it is found out that his disability he is eligible under this quota, then you give admission. Like that is what was done. So that's a fair approach to you as well as this thing. We are delving into the matter which is to be dealt with by experts. None of us know what is the extent of disability, how much it is, and so let it be. You please suggest.
Already, Milord, you have referred to the medical board as per the rules, Milord. Sarojini Eye Hospital is the highest medical, Milord, the hospital. Highest medical officer in the state of Telangana. The disability was assessed 50%. We will not entitled for the the reservation. Milord, if Lordship Milord intends to refer to the another hospital, Milord, we are ready.
No, all right. So
Milord,
the disability should be how much? 40%.
40 above, Lordship.
Above 40.
40 and above.
So what basis you say, Mr. that?
48,
Just a minute.
Page,
You understood now? Huh? So what basis you say that the this?
page 48.
Just a minute. Same thing we told the young man. Huh? You don't want to answer already. Page 48. Yes. You don't want to listen to our query. Fine. Yes. 48. Huh?
What is the certificate issued by the government hospital of Telangana where it states that my disability is 40%. Percentage of disability, fourth point, percentage of disability in her case is 40%. Lordship, this certificate is issued on 2nd March 2023. Lord, this certificate, Lordship, we just.
Anything else?
Lordship, so
You are not allowing us to put questions, so we cannot put question. You say whatever you want to say.
sorry.
No, say whatever you want to. Yes. So it is issued on 2nd March 23. That
So, Lordship, so on this category, Lordship, we seek that a case may be considered. Because as per the rules, Lordship, up to 40% and more, she is eligible for quota and period.
yes.
Lord, there is a medical report of Lord Sarojini Devi Eye Hospital.
Which he has not annexed. So let us hear him first, then we get back to you for relevant questions. Yes, please.
Lordship, as
Ah.
per the rules, Lordships, of National Medical Commission rules, Lordships gets at page
Ah.
14. As per the disability visual impairment, Lordship, the need type to copy is at page 17, Lordships, appendix H. B, Lordship. Visual impairment, blindness or low vision less than 40% is not for equal to or more than 40% disability, she is eligible, Lordship. So if it is, she is equal or
It's used in short.
if it is equal or more than 40%, she is available for PWD quota. As
More than 40%, equal to or more than 40%.
He or she is eligible because less than 30%. See, we are not eligible for medical course.
Not eligible for the.
See, say equal to 40%. He relies on a certificate which says 40%. How will he eligible?
Equal to or more, so 40 plus.
So even if it is 40, then she is not eligible. Equal to 40% or more than 40%.
Equal to 40 means less than 40 plus. So 40 and plus.
So 40 and plus. She is not eligible as per home document P5 because it says 40%. It says no, equal to or
More than equal
this is means equal to 40%
or more than
40%. So it means equal 40% or more. So increasing 40% not that. It can be 40%. Also seems to be ineligible. Equal to 40% or more than 40%.
then there should also be anything more than 40%. But equal to, when they use the word equal to, it's not with 39.9, they're not. Onwards, maybe
No, it says not eligible.
not eligible for me.
Not eligible.
No,
So if it's 40 or more, they are not eligible. Up to 39%, less than 40%. See, less than 49.99. If it's for, otherwise, this meaning will be rendered correct.
This is taken.
No, but in on page 48, Government of Telangana, which says 40%. That's what is referred. It's certificate where form is what.
We don't, this is given by Institute of Welfare Office, Sarojini Hospital.
Subsequently, 24th July. Less than 30%.
Then automatically this interpretation is taken, then automatically should be first available when you ask Mr. Rao.
Yes, Mr.
in similar situation as error, Lordship, your Lordship, page 24, 74, Lordship passed an order. Before page 74, Lordships.
That's what I was telling, no, Mr. Rao, that we have, as a judge in Karnataka, I have passed. So you should have said that page 74 is that order. First thing, controversy involved is I want to refer to division bench judgment to which your lordship was a party.
Page 5, when two contradictory reports are there, Lordship, paragraph 5.
Fine.
Directed to be.
Yes.
Let
Mr. Prabhakar.
Yes, Lordship.
I cannot depart from that view.
Lord, Gandhi Hospital, Lord.
Which?
Lordship, referring to the Gandhi Hospital, Lord.
Gandhi Hospital.
There is, my lord, the ophthalmology department is there, my lord.
Gandhi Hospital is a government hospital.
Government hospital.
So when he should appear?
Let me fix a date, my lord.
Tell us, when will you appear, Mr.?
So, Saturday,
Saturday, tomorrow,
Yes.
day after,
Day after.
11 a.m.,
Yes, so
19.8.
yes,
much good.
This thing ophthalmo department shall examine him and give a report on the same day.
yes,
Same day, and seal cover you give it to us.
yes, lord.
You will give in seal cover, not he. He is university. So Mr. Prabhakar Rao is agreeing to everything on your behalf. He knows that you won't. Yes. Yes, madam.
One more matter also there.
Wait just a minute. In this, the petitioner, mark everybody's presence. Petitioner is a person with disability. The petitioner in this writ petition, petitioner is a person with disability and according to him suffers from disability, suffers from visual impairment, which is less than 40%, right? Less than 40%.
40%.
My lords, one report has stated 40%.
So, madam, the situation is like this, Mr. Rao. We have read it. That's what we were discussing. That's what happens when you prevent the court from asking questions. Mr. Counsel, you should realize this. You don't get the benefit of what is transpiring. We were trying to put questions to you. You said 48 instead of answering. So he is not getting it right. The correct position, according to us, is that if a candidate has less than 40% on a certificate against him saying that I am 40% disabled, but we could have dismissed it, but we don't want to do it because your certificate itself says, Mr. Rao, certificate produced by it that 30%.
30%.
So as per your own document, he is entitled.
No,
he is arguing against.
He is entitled for not on DWD category. He is entitled, but not DWD category.
But not eligible for PWD. So, like that, here in the option itself.
So it is, yes, correct.
Yes.
I was missing the distinction, which brother has pointed out.
Yes.
So position is that this thing less than 40% disability, he is not eligible under PWD quota,
Yes.
but eligible for medical course.
Yes.
And if he is 40% or more, then he is entitled. And there are two reports. One is 40%, another is 30%.
Yes.
So therefore, as suggested by you, like you should suggest that ophthalmology of Gandhi Medical College, Gandhi Hospital, Hyderabad. Paragraph. What is written? Yes. No, visual impairment to the extent of 40%. list on 21/8.
Have the copy by tomorrow, but
Yes, today you will get it by evening.
Evening, copy today.
even item number 15 is also same.
Huh?
15 also.
15 save.
Same.
Whatever it is, it will go for a third independent.
He has not applied under disability quota. Oh,
So we applied in disability quota. Lordships,
Let us see, then let us go
Ah.
by the one after the other.
one out, then don't, that's why. It will be called.
Fact then.
Called. It will be called.
Ah.
No, 14 what happened?
15 what happened?
Local candidate, right?
That is over.
Oh, 15. Yes, your case, tomorrow. Yes, you didn't apply, Mr. Rao. Where is it?
45 Lordships, page 45.
Oh, same 45.
45 Lordship, serial number 19.
See, Mr. Rao.
Serial Purvasi.
A Siddhartha, BCB. What cat? Cat means category.
PWD category Lordships.
Huh?
PWD category. This is
It
a list
says-
of not eligible candidates of PWD category.
It seems like yes. Mr. Rao, come to page 44, PWD category. So what are the facts in your case? What are the two certificates, Mr.? One is
Same Lordship, it's a exam
40.
48 Lordships.
Government. Well, government is more liberal, right? Huh? Everybody you say that he is eligible, right? Madam, and which is the other, Mr. Rao? In this case? No, that's correct. But where is the other thing?
Hospital is there or some other hospital?
What about you produced right report? In his case, how have you rejected his claim? Because 48 says that he is 40%. He has got the report. Same order, madam. So the first report is issued by Government of Andhra Pradesh, dated 25/12/2014, right? The date was different. And Mr. Rao has produced report on examination so and so, by whatever, by, yes, by, this report is by
Same.
Sarojini Devi so and so, dated 24/7/2023, which shows 30%, right? Same order. So therefore, same order. But Mr. Rao, you will agree that one eye is artificial, and despite that it's saying 30%. Sarojini, like it has to be different, right? How same 30%? Monday.
May I please?
Of course.
It's a register objection, my lords, on the maintainability, because I have challenged an order passed by NCLAT, my lords, in this matter. NCLAT dismissed my application, my lords, on the ground that I have filed it beyond the period of limitation, my lords. Whereas if the order copy itself was made ready on 1/8/2023, 2022, my lords, and I filed it within the period of 45 days.
1/8/2022.
My lords.
And when did you file?
Lordship, may kindly take the order copy prepared by the tribunal.
Hey, Mr. When did you file?
Order. I filed it on. Millard, I filed it on 9/9, Millard.
This is filed on 9.
I filed the application on.
So what has been done by the impugned order? Your appeal is dismissed as.
Millard, my appeal is dismissed as not being filed within limitation, Millard. 45 days.
Learn it. Yes. What office objection, right? After hearing learned counsel for the petitioner, office objection is overruled.
I have one more submission, Manoj. Similar matter between the same parties, not challenging another order, not is before learned single judge, not. And learned single judge has.
You have to file an application, not after admission when the court notice.
Much obliged. No, I apologize.
File an application.
Much obliged.
But in this matter, I'm appearing for GHMC. My lord. In last occasion, we have sought time for filing counter.
Not filing.
We have complied.
Who will appear?
My lord,
No, for not filing counter.
no, my lord, we already filed our counter. Filed counter. My lord, the property is seized under 460.
Acha.
One respectful submission, my lord. The property is seized under 461A, my lord. Along with the counter, we have already filed the photographs. Statutory.
He wants to file.
I have to file
Petition, learned counsel for the petitioner, praise warrant is granted. 4 weeks time to enable him to file counter.
Much up.
Counter to the reply to the counter filed on behalf of respondents 1 to 5. Which case, madam?
Item 18G, Vilna is
I picked up paper petition as well.
on behalf of the respondent. Senior counsel A. Venkatesh Reddy is on legs before court 10 your lordship.
No legs, right? You have been only restrained by not to create third party interest. This is what it is. Why do you want to alienate the properties? What is the stage of?
I've only shot.
What is?
She's the respondent. I'm the petitioner.
That's why the confusion. Like both are petitioners, so she should go there.
I'm the petitioner.
This all is what this see here. It looks like we are telling you petitioner. Then it is respondent. So she is standing for petitioner. We thought that she is appearing for appellant and seeking adjournment.
I apologize, your lordship.
Go that side, madam. Yes.
I have only one point to add.
Nothing, no point. What is the stage? This is 2022.
2022, the order came to us in 2023. We filed the appeal within 1 month.
No, that's correct. What is the stage of arbitration proceeding?
That's my point. They have not commenced arbitration proceedings.
Not commenced.
Section 9(2) of the Arbitration Act.
Why?
Section 9(2) of the Arbitration Act categorically states, my lord, that arbitration proceedings must be commenced within 90 days of the order. The order came, my lord, in ad interim order was given on 28/12/2019.
No, 28/9/2022.
That's a final order. The ad interim order was given on 28/12/2019 at page 51 of the order. Section 9(2) of the Arbitration Act, my lord, categorically states that once you obtain an order under Section 9 interim order, you must commence arbitration proceedings within 90 days.
So what is the effect if it's not commenced?
The
order goes.
Two division benches of the Karnataka High Court have categorically held.
Which is the one?
is to be issued only with the intention to commence the arbitration within now.
We will give the time they are recording on this, so that next time it's easier.
Two
Save
Indian
time.
benches of the cap.
Yes, Sundaram.
Hmm.
Sundaram.
Yes, Sundaram panel.
Sundaram.
First judgment on this.
Is it delay? 4 years. Wait. My lordship may take the first one.
Ah.
No.
Which
Cash and carry.
Patent Construction Private Limited, the first division bench.
Yes.
PATON, short one.
Yes.
The next, it's only short paragraph, right? On the next page.
So. So we said something severe. Yeah, like this. Yes.
The short answer the Karnataka High Court gave is that the order gets automatically vacated. I'm reading just below.
Yes.
Section 9(2), where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1. The arbitral proceedings shall be commenced within a period of 90 days from the date of such order, within such further time as the court may determine. As per the above subsection, where a court passes an order for any interim.
Correct. Yes, got it.
Not the same. So
yes, madam. So therefore, no standing.
Passover. No question.
This is the first point.
You said 1 point. Thereafter arguing again. Is it? Don't you think it's sufficient?
This is dispositive of the entire issue. This is dispositive of the entire
And suppose if there is need to hear you further, I mean you will definitely be heard.
Yes.
This is enough to this thing for her to handle, right?
Yes.
Correct. Legislative mandate, but nothing your senior can also do about it. That's why he is on his legs. Lighter vein. We will pass over. Let him come. Yes. Mr. Prabhakar, what did
to grant the leave to file the writ appeal,
Why?
the order dated 7/7/2021 of learned civil judge Millard, the area which belongs to the 5th schedule.
Who are the respondents?
Respondents, Millard, last occasion, one.
Everybody appears
before your lordships. It didn't come before your
One and
lordships.
two.
For official response.
1, 2, 3. Who appears? Served or not?
Yes, already they filed the wakalatnama, Millard.
Counter to leave application they didn't file.
Yes.
Despite Mr. Prabhakar, none for respondents number 1 to 3. Mr. So additional advocate general for respondent official whatever respond. Let. Mark heard learned counsel for parties on IA 2 of 23 for the reasons assigned. This all have. Madam, you have this pro forma thing, sufficient cause for condonation of delay of how many days?
430 days.
Made out delay in condone. Appeal is admitted for hearing.
Lordship may please to force along with. Well, against the same single judge order, my lord, writ appeals were filed by the state government, which are coming up on 21/8/2023.
Number list along with.
My lord, writ
We
appeal
hope
number.
that you have got the numbers correct, right?
Yes.
On that day, you will say my case has nothing to do with the file. Huh?
I have the numbers
Correct,
of
no?
those writ appeals, my lord. Writ appeal
As
number
prayed by learned additional advocate general list for analogous hearing along with.
along with the writ appeal number 448 of 2023 and 480 of 2020.
Got it? Yes. No. Next.
But- And but in my humble submission, the matter is covered by 2014 15 SEC page 197, saying that the Human Rights Commission has nothing to do with the civil dispute. Now, on the merits of the matter, it is like this. Two individuals.
No, but who are you?
I am the, I just give me 2 minutes time. Two individuals who were having houses there decided to demolish the existing houses. Instead, thereof construct apartments. They applied for a.
Who decided? Who decided? Appellants decided to construct.
The
Petitioners.
The appellants.
Petitioners.
Petitioners.
Petitioners
Petitioners decided to construct. They obtained a permission. They constructed strictly in accordance with sanction so given by the
construct a residential complex.
residential complex.
Then
the respondent herein offered to purchase one for 58 lakhs 28,000 rupees, out of which 22 lakhs.
You people are builders, right?
I am not the builder, my lord. They are the owners.
Landowners.
Third is the builder. He entered with the owner.
You said that petitioner decided to construct and got it constructed through someone. Contractor.
Demolished, constructed. At that particular point of time, in one of the blocks, the respondent wanted to purchase. Then he gives a complaint to the Human Rights Commission that he entered into a contract with an unregistered document, unregistered agreement of sale, the total consideration of which is
No, so R5 entered into an agreement with you.
Unregistered contract with
you.
Yes.
Petitioners.
Yes, for purchase of one flat for a total consideration of 58 lakh 28,000. That is what he alleges or avers before the State Human Commission, and then he is still yet to due 22 lakh 28,000. Then he seeks
22 lakhs
28,000.
28. No, but who handed over possession? You have
Possession, my lord, what happened is
you have given possession.
I have not given possession. Please listen. Please, I
No, therefore we are asking. Yes, relevant question.
When we were getting the thing done, he said he wants to lay his own tiles. So we said we gave him the key so that he lays his own tiles. Even as of now, he is not living there in respect of an unregistered contract. Then he moves the HRC. HRC says I should give him water connection. I myself did not have water connection. From one borewell, from the other block, we were using the whole thing. Then he gives a police complaint and all these things. Then I approached this honorable court. This honorable court granted an interim order on 25/4/2022.
So, what was the prayer before HRC?
HRC is to direct us to give water connection to them. Lots of prayers were there. Incidentally, that was one.
So,
Human Rights
the Human Rights Commission
Your Lordship could get at page number
order dated which order?
57 is the Human Rights Commission.
Order dated Human Rights Commission, Madam, order dated 11/3.
11/3/2022. 11/3/2022 is the order of which this honorable.
We have dealt with this. What do you?
Yes.
No. Great respect is all right. We are on section 12 as
senior counsel is not applicable to this case.
Ah.
Now here, my lord, the issue is, my lord, only to disruption of water supply to this particular flat by the builders as well as the owners, my lord. All three are the petition before the honorable court. And my lord, upon such disruption of water supply, prior to that,
1 minute, Mr.
what is
Koteshwar.
happened?
Have you given OC? Have you given OC? That is the end of the matter. That is why I am saying you, before, without occupancy certificate, if a building cannot be occupied.
Yes.
That is why I am asked that question.
But that issue also clarified before the honorable court, my lord. Without any such occupancy certificate,
Construction completion certificate.
Ah, yes.
sir, without any such occupancy certificate, my lord, no, the people are living in the same premises. All the respondents are living, and some of the flats were sold to third parties. They are also living in the same property, my lord. Except me, my lord, all others are enjoying the civic amenities of the same building, my lord. So when, my lord, but after execution, my lord, after agreement of sale, I paid entire sale, my lord. When they have disrupted water supply, my lord, then I have approached the Human Rights Commission, only praying the commission, my lord, to restore water supply, my lord. Accordingly, my lord, they have passed an order on 11/3/2020.
There is an interim order granted by this court on some date.
Interim order granted initially by the.
Ah, so then how are you surviving since then?
Pardon?
Without water?
Blood, I am drawing water, blood, from the outside tap, which is a municipal water, which is the tap is very much available.
Continue to do so.
I find all the photographs. Blood,
No, despite an interim order, if you are surviving, then survive for few more days.
violated the order passed by the honorable court, blood.
That is not the question. The question is, under section 12 of the Act, whether Human Rights Commission has power to pass such an order.
But order is, blood, only, blood.
To supply electricity, that according to you, under section 21(12), it can be done. That's the answer, right?
Yes, even blood, here in blood, only title is not the issue here, blood. Here the issue is only, blood, the restoration of water supply, blood.
Yes.
Blood, here is.
So where is occupancy certificate?
But occupancy set.
Where is it? We are asking you a question, then we will write in the order that pursuant to query made. What is your answer?
I clearly mentioned in my counter.
Not there.
Saying that there is no occupancy certificate.
Right.
Man, without occupancy certificates.
You have occupied.
Builder owners have inducted all the persons and they are living in the property lots. They are living in the property. Lordship, kindly ascertain the same.
Permission was valid till what time? When it was granted, when it is valid? Till what date it is valid? So the 3-year period is also over. So
it expired when? 22. 21/4/2022. All right.
But I find photographs, blood, which clearly shows that people are living in the property. But you ask me kindly.
No, we are not saying, we are not deciding this case on the basis of photographs, but in view of judgment of Supreme Court in 2004, Manikamma, if you are not read it, 1415 SSC 197.
But my only endeavor is, Millard, I would like to distinguish, Millard, one aspect. But my issue is, Millard, not pertaining to title. Violation of human rights, Millard, by disrupting the water supply.
By a person who is occupying the building illegally, and he claims that his human rights should be protected.
But on that aspect, Millard, my respectful answer to this court is, Millard, by virtue of a sale agreement, Millard, I paid entire sale consideration. And the balance sale consideration, Millard, I have issued a check, Millard. Will ask me kindly peruse, Millard, my document which I placed before the sample court, along with my contract.
No. So therefore, the suit for a specific performance of contract brought by you as a respondent in the writ petition should be decreed here, granting you a decree, asking him to execute a sale deed, and thereafter dismiss his petition.
No, that is not my intention,
Yeah,
Lordship.
what intention?
Not there.
We are not going to go into this that he has paid it, you did not pay, and he did not accept. We are not going to go on this. File a suit for a specific performance of
That
contract.
already notice have been exchanged, my lord.
Done, no?
Notice have been exchanged, my lord.
Why?
But-
There are two suits, one by us for cancellation of the
I have not filed any suit.
another by him for
I have
performance.
not filed the Lordship. The Lordship kindly permit. After passing an order by this honorable court and
So we
notified
wonder
order-
what all, I mean, merely because value of property is more, what all you argue in 226, right? Arguing everything, right? Suit for a specific performance of contract, everything.
But I am conscious.
You
that
are a
I-
respondent, file a petition, we will deal with your petition.
No, my lord.
Seek
I
a
am-
decree
I am
for a
only-
specific
but I am
performance
only
of contract.
I'm only responding. to
No,
that.
the only thing is section 12 is interpreted by Supreme Court in this Manikamma's case and it has been held that it has no jurisdiction. Despite that, you are arguing and showing us photograph. What else can we say?
Even, Lordship kindly permit.
No, had I been in your place, I would have said that I cannot defend this order.
But
As a counsel, I would have said, and add the track record, check it from Madhya Pradesh High Court. People will tell you that I never opposed the genuine this thing.
I get great.
You argue.
As well as.
No, great. You have the respect for us. We know it. Please argue.
My only submission, not only to protect the interests of my client, I'm only few facts I am bringing to this honorable court notice.
In a writ petition preferred by him, we should protect your interest. This is the argument we will write.
Because, in the order also, in the order passed by the Human Rights Commission, it's clearly mentioned, Lordship, because they have disconnected water supply, it's violation of basic human right. Therefore, the court, the commission ordered only to restore water supply, Lordship. They're not into the title aspect, Lordship.
The moment we dismiss the petition, I will possibly enter the house and continue living there without filing the suit for specific performance. They have to go to civil court, they will resolve it. Yes.
But the Human Rights Commission also very consciously they are not well with the title aspect only because as in the date I am in possession of the property and water supply the respondent petition directed to restore water supply, Lordship. Thereafter, after passing an order by the honorable court on 25/4/2022, when the matter came up for hearing, the both parties were reported before the honorable court to work out our remedies outside, Lordship. Then we had a discussions. And in
Not
that
possible any solution.
in the discussions also.
But I gave them.
It's only a question of money, right?
Whatever. I gave him this offer. Whatever amount you have paid, I'll return. If you have spent anything, I will return with some escalation. What amount you have paid, I'll pay bank interest, simple interest. This
No,
is what we offer.
what is the amount due to you according?
According to them, compounding interest, Dandupattu scheme of interest, and then astronomical figure of almost 3 crores. Now it's sought to be asked.
No, but sir, what is the amount due to you under that agreement in order to execute it? The mutual, the offer has to be both ways.
22,68,000 is
With
due
the
from him.
remainder.
He is
So
to give that.
Give, and so what amount you will execute a sale deed?
Milord, for the
How much if he pays, you will execute a sale deed?
Milord,
You have to tell your figure also, no?
Milord, I don't want
Yes,
to
you-
execute a sale deed. I want to return his money.
Oh,
But in fact, they have collected 1,67 lakhs, was the price. Out of which, I've already paid 1.45.
can we refer it to mediation?
And the balance payment is,
But I don't want such a person to be my neighbor.
You are a neighbor. You are the
Neighbor.
owner.
only
But,
pay
absolutely no, but due respect. But he has no, with due respect, the Human Rights Commission has no jurisdiction. Now
So
that
that's correct.
criminal cases.
I need not argue, we have already taken a
Correct.
view,
Now
but
that-
we are
now-
trying to, that's why alternative
Now that
dispute.
criminal cases, civil cases are already filed and pending, they would be decided on their own merit.
Lakshmi, when we requested to restore water supply or to execute the sale deed, balance sale consideration is only 15 lakhs and all.
3 minutes more. You have been arguing for 8 minutes, 3 minutes more.
Yes.
It's not more than this.
Yes, I'll conclude. But then, we were requested them to
As per the.
No, you are not saying anything about the Supreme Court arguing contrary to Supreme Court judgment and say that I will conclude. How do you meet this judgment, Mr.? 2014-15 SCC.
Your Lordship may kindly have this matter.
No.
Our Lordship may kindly pass over.
No, nothing. This is all. You said I want to argue. We have heard. We are only asking you. How do you meet this judgment?
My only
No
answer,
answer.
my only endeavor, Lord, that particular judgment is Lordship
Are
regarding
not- did not
title issue.
apply.
The title issue is not applicable.
We have understood. There
Yes,
is
sir. So
no
my case
dispute
is,
of title.
my case is Lordship.
Water and electricity.
Water only, not electricity. But they have also disconnected water, electricity supply. And not they filed a writ petition.
So we have got it that the claim is not with regard to title but with regard to
Yes,
water. Therefore, Commission has jurisdiction to pass an order. Thank you. Anything else?
With regard to the payment, whatever due,
No, we
that
don't-
need to be paid at
we only
the
try
time
to
of
explore.
registration of a sale deed, Lordship. But as per the clause, that need to be paid at the time of registration of sale deed. Accordingly, I have issued a notice, to come forward to execute the sale deed, which they refused to come forward. I mean, after negotiations, with the elders, they agreed to execute the sale deed, and they have collected, again 22 lakh rupees by way of a check. And afterwards, they have issued a draft sale deed, and then they have inducted me in possession of the property. These are the factual aspects which they have not denied at all, Lordship. But since I am living in the flat, the Emanates Commission has restored water supply, I filed a document evidence regarding payment of balance sale consideration also, Lordship. Lordship, kindly, regarding payment also, Lordship. I clearly, but the issue is, since I have lodged a complaint to the GHMC municipal body regarding unauthorized construction in the common areas, preventing parking, and also raising construction on the top floor, on the terrace,
Approach the appropriate forum for redressal of your grievance for supply of water. Human rights has no jurisdiction. If you don't know, ask senior counsel where to go. He will advise. Human Rights Commission has no authority.
Lordship, so pleases, anyway, you notice have been exchanged, regarding invocation of special performance, before the competent civil court, for which notice have already been issued, Lordship. And even they filed a suit, for eviction of me from the premises, Lord. They have admitted that I am.
So you really want to argue this case till 4:30? We were not serious about it when we said so.
I leave it this honorable.
You have to leave. Everybody has to leave to this honorable court. This court will leave it to law. Whatever law says. We don't have a discretion in the matter. Fine.
My only idea with Lordship, having received substantial consideration, and with that money they have constructed a building and they have sold the property to various third parties. Except me, all others are enjoying the property, Lord. And now
you should also enjoy without water and electricity. We are not saying you shouldn't enjoy.
With the municipal water, Lord, I am drawing from the down floor, Lord. I am living with the bare requirement, bare necessities, Lord.
That's it, Mr. 5 minutes are over. We said 3 minutes, 5 minutes are over. Thank you. Thank you for the assistance rendered to us. Yes, no submission. He doesn't understand. You also don't understand.
Document certificate has not been issued.
This mark the presence. With consent of the parties, the petition is heard finally. In this writ petition, the petitioners impugn
Suit for
Mister, he has submitted. We cannot prevent him from submitting anything. If he is wrong. You this thing. Remedies go to Supreme Court against this order. Don't interrupt when order. We will haul you up for contempt. This is interference in administration of justice when the court is dictating an order. And we have not record. Even if we record a wrong finding, you have to bear with it, and at the end of this thing you have to say something if you want to factually incorrect. You cannot tell us what view to take. Huh? Don't this thing that his petition should be dismissed with cost of 1 crore. Don't tell us. Warning for you. It's a case, right? Are you involved in this case? You are residing in the flat? No. Then your family member? Then why are you so impatient? You have argued it, right? Interrupting when the order is being, this is impermissible in our court. Sit down and we will make you available the copy of the order. Go to Delhi. Yes.
To sale of Ganesh idols, my lord. In fact, this entry models were passed last occasion, your lordship, which is covering it. An item.
But I had sought for time. But I'm told that the meeting has been called by the concerned departments, today. But should be deferred by maybe for a place before my lord, not meet.
So what they want to immerse the idols in water body, petitioners.
Sell the idols.
Making of plaster.
You want to make plaster of Paris idols.
Yes.
That direction, all of the court directly work, that some permissions cannot be granted. And
Granted?
earlier, my lords.
No, see, mister, if they make plaster of Paris thing, right? People will definitely take it to water bodies.
Too much. But I'll seek instructions from the state, because this interdepartmental meetings have been called, to decide. I'm told today or tomorrow.
Yes, madam, right? See, we are adjourning it to next week, right? You just now heard additional. No, you also want to make plaster of Paris idols. Yes, no, that's what we are agreeing with you. That's what we said. We'll hear you on.
Pollution control board to see how their guidelines are.
Central Pollution Control Board.
They have filed an affidavit.
Some guidelines.
Yes.
They have to ensure.
You are
that
Mr.
guidelines
Praveen, you are appearing for Mr.
I'm for the Union of India.
Central Pollution Control Board.
Other council is there.
Central Pollution Control Board.
They have issued some guidelines for the state
Find
to
out.
follow.
So in WP number 28931/2022, the right of the petitioner. We have fixed some 30th August. 30th August 2023. In the other petition, you write the petitioner. What do you seek in this petition? Give the other matter file. 22.
Appearing in the item number 22, which is connected, and a common order was passed in both the petitions, by this honorable court.
You are intervener or petitioner?
I am the petitioner.
Fine.
I am the petitioner in the item number.
Same issue, right? Same issue, plaster of Paris. Same issue. In WP number so and so 19639 and other petition also, right? First one and this petition. Issue this thing. And he opposes. So list on 30th August 23. Yes.
May I make a submission, my lord?
30th August, Mr. Council, 30th August.
I heard, my lord,
Listen.
one submission I'll make, I leave it to your lordship.
Ah.
There is a common order passed by this honorable court after hearing all the parties that was dated 21/7/2022, which was not brought to the notice of this honorable court now.
All right. It will be open for learned senior counsel for the petitioner to bring to the notice to refer to order dated 21/7/2022 by division bench of this court in which petition?
in in both the writ petitions, item number 21 and 22.
In item, that's all. Interim order passed by this court on 21/7/2022 on the next date of hearing.
Yes.
List on 30th August 23.
Deeply obliged.
Move faster, man. Move
May I
faster.
beg for leave in this matter, my lord? Petitioner
Counter by Pollution Control Board
Yes, we filed the counter in this matter.
filed.
Filed counter. Yeah.
You want to file any reply?
Yes, my lord, your lordship may grant short time.
Admitted for hearing. Praise warrant is learned counsel for petitioner. Praise warrant is granted. 3 weeks time to enable him to file a reply to the counter.
Deeply obliged.
Admit for hearing.
Derived out of an order of HRC.
24.
Item 24, I appear for the petitioner's lordship. Order rising out of a writ petition arises out of an order from HRC concerning
same right.
Slightly different in the sense it is concerning liquidation proceedings where the petitioner had purchased certain assets from the liquidator.
Assets of the company have been sold by the liquidator. And these people who claim to be occupying that land of the company, previous company, which is in liquidation.
But just now we have taken
Yes, same
view. We have taken a view just now in.
Yes.
You have.
I was in the courtroom here.
And we are bound by that order.
Yes, your lordship. I was covered by that order.
Covered, no?
In the sense.
Oh, you are happy, right?
Yes.
With the order. Huh? Yes, yes, madam.
List of dates, your lordship, only for the convenience of time.
Correct. Same terms and.
Yes, you know, same, I don't make any change.
Same, this thing allowed. This.
For instance, they have also asked for labor benefits, which are also not covered under HRC. It's the only difference.
When we are saying just now to save time, we are not dictating it that we will do it between 1:30 to 2:30, right? You get the copy of the order today if you are in a hurry.
No.
Not in a hurry.
Absolutely.
Fine. Disposed of. Same terms as item.
Disposed of other day.
Other case.
Other case, same order.
Item 23 D, so this.
I'm so sorry.
Item 20 is fine. Item 20 is quite good. No, chip.
Your lordship, in item 24, one small submission. Because the matter also had come up before the single judge in an
No, already
order. Only
no, nothing.
Which
If you
one?
want
My
to
order.
still argue despite that, when we are disposed, then we will admit it, Mr.
No, your
You are
lordship, only
not,
fact
not
that-
ready. You have not got instructions from the petitioner, therefore you are uncomfortable that my petition is being allowed.
No, not all, your lordship. Only one fact had to be brought
What's,
in.
Mr.? We have told that it's being allowed. You have heard the order.
Yes, sir.
I mean, I don't know when petition is being allowed. Despite that, you want to argue.
My apologies.
No apology. But you should realize, Mr. We are not sitting here to seek apologies from council. This is not contempt proceeding. But you should realize, right? Why we are doing it, we could have dictated, but to save time so that 15 minutes more cases can be taken up. This is the endeavor. So please appreciate this and understand. Every moment of this court is precious because today we are slightly running behind schedule only at item 25. So with a view to hurry up. One order we have just now dictated in open court, same facts, 2 paragraphs and same will follow.
Yes,
We told you, counsel for HSRC agreed.
Yes,
Despite that you want to argue. What knows? Allowed, mister. Be happy, at least smile. Petition is allowed. Excellent arguments. Yes. Yes.
Item 25, Your Lordship.
Yes.
I beg to represent the petitioner counsel. Matter concerns, Your Lordship, allocation of.
No, you are not entitled to any relief. You have already superannuated, right?
Your Lordship, may I make one submission, Lordship. As a matter of law and under the guidelines.
You are seeking reinstatement.
Your Lordship,
That is over.
in Andhra Pradesh, Your Lordship, I can still be reinstated because 62 is the retirement age there.
So, let's say tomorrow this state makes 63, you'll come back again.
And make represent. Nothing
Because-
survives, mister.
Your Lordship, as per the guidelines, I'm entitled to be allocated to the state of Andhra Pradesh. But that guidelines, Lord, in fact, in the counter filed by the state of Andhra Pradesh, they say that my earlier request is only pending. They have not even rejected. Lordship, initially, I made a request for transfer to Andhra Pradesh.
No, you have already attained the age of 58 years. Therefore, they have said
Your Lordship,
Telangana, it is 61, AP is
61.
62.
So he said, they say 51.
No, now 61 is also over.
Only if I'm allotted to Andhra Pradesh, Your Lordship, I'll still
You
have
will
one
get
more year
one
of
more-
service, Your Lordship.
No, that's why I said if by any chance Telangana makes it 63, you'll come back here.
He was allotted to the state of, he was allocated to the state of Telangana. And the entire superannuation.
When allocated?
The allocation is not there, but he was allocated to state
So-
of Telangana.
Superannuation on 31st July 2020. And then he wanted to go to Andhra Pradesh because the age of superannuation is 62. That was rejected by the state of
What
Telangana.
is this? You should realize this.
Great
Have you challenged the order of allocation?
No.
How did you serve in state of Telangana up to 31st July 20?
Lordship, from 2017 onwards, I've been making representations, even in the counter they indicate that
Representation people continue making for 40 years also.
if they don't count, Your Lordship may kindly say,
Have you challenged the order of allocation of your services to state of Telangana?
Your Lordship, after I was contesting,
You have, in other words, you have accepted allocation of services to state of Telangana, having served here and fence sitting. Andhra said that 62 years you immediately wanted to go Andhra. Then brother rightly said that if Telangana makes it 64, you will say, I want to come to Telangana. It's too late in the day.
the record would
We
reveal,
have
Your
understood.
Lordship, the record does
Understood.
Your Lordship, will make
Please make northward journey advisable. Weather is good also. This writ petition, comma, the petitioner mark the presence, the Bharti Pen. Liberty. Yes, of course. In that case also we granted appropriate remedy. In this writ petition, the petitioner, namely Telangana State Power Generation Corporation Limited, herein after referred to the corporation, has assailed the validity of order dated 10/11/2022 passed by Telangana State Human Rights Commission, herein after referred to as the commission, by which the commission has entertained the dispute. Commission has entertained the whether you should,
Petition is filed before the Andhra Pradesh also, WP 6475.
Learned Counsel for the petitioner seeks leave of this court to withdraw the petition as
And pursue
in,
the
and as in pursuance of order dated 11/1/2023 passed by division bench of this court, the petitioner has already filed a writ petition before the
60
Andhra Pradesh High Court.
64.
Paragraph in view of aforesaid submission, the writ petition is dismissed as withdrawn with the liberty to the petitioner to pursue the writ petition filed by him before High Court of Andhra Pradesh.
WP numbers.
A WP number, whatever, give it.
6475 of 2023.
WP number 6475 of
23. Oblige losses.
Whatever petition you file, everything prosecute. We cannot control. Yes.
Item 29.
To 34.
Yes, ma'am.
Which phase to so we regulatory committee is not there. Then what? Why they should come here? Yes.
My lord, this present.
No. So is there a fee regulatory committee
Yes, my lord.
here?
Yes.
Must be.
Yes.
So what is your grievance?
My lord, in my case, to
This
item
government order. You are challenging the government.
government, GO 20, my lord.
What?
This in my item 29 and 4 matters are filed by Sandeep. They were not filed counter so far, my lord.
Barred by what?
Item 29, my lord.
In 29 counter file notes.
File.
Counter. GP medical health is GP medical term.
Don't wait for us. Which case you are appealing?
29, my lord. 29, I have not filed counter.
You
I am appealing to respond number 4, 29.
You should say in the beginning, the petition is admitted for hearing. Learned counsel for respond number 4, praise for is granted 3 weeks time to enable him to file counter.
Applies. On the batch.
At batch 34. Up to 34 admitted, yes.
Something to your lord's favor, may I say this? That this fees is will be every year charging the paid assembly is that because by the time the court decides the matter, the
No,
students
please.
are going out. That
Please.
is the date for the year.
No, please file an application for early hearing. We'll fix a date.
You already
Not at the time of admission, merely because it is admitted. You file an application saying this academic session will come to an end. This is the issue involved. You have to prepare a synopsis to assist us so that we can hear it out of turn.
Other side, we also filed counter 2020 matter, Milad. That's why I'm requesting a lot. It is 2020.
We have told you what to do.
That's right, Milad. Even
You will not do it. Your colleagues will do it, right?
Yeah, that's
Let
right.
them, let young people with you work and learn. We are sure that they will learn something if they prepare a synopsis and an application for urgent hearing.
Pleadings are also complete. Pleadings are also complete.
Yes,
therefore-
all right. Pleadings are complete, madam, right?
Item
Pleadings
30
are
I'm
complete. Petition is admitted for hearing, so and so rejoinder.
Item 30.
counter.
Pleadings are not complete.
Not complete. Other
Not
matters
in all
not complete.
matters.
Hold on. In my matter, item 30, pleadings are complete.
So this is what happens that these people get it tagged and then say my case is different. Your case seems to be different than him.
No, the common people is common. All are common.
They're all common.
Please file, Mr. Please prepare a synopsis. Ask
very well
juniors to prepare synopsis to cut short the time, and we will hear it.
Only
File
request
an
you will also
application
give
for
us some
urgent hearing.
time, my lord, fix the time so that, my lord, that day by that time we will have that application coming.
Yes. So
Otherwise,
Mr. We have admitted it. He is opposing admission, saying that don't oppose, don't admit and fix a date for hearing on Saturday. That's what is going about. Yes. Lighter vein, senior counsel, you must at least good to see all of you smiling. Right. Yes. Yes. Huh? No, you are not appearing, right? Oh, yes. Yes. Counter. Yes, this is Mr. Ravi Chandar's case. Yes. See how it's a similar issue interpreting rule 9. That's how we remember. Security interest rules, correct? Division bench, you said that Karnataka view is my
job is
in your favor.
My job is easy because your lordship's judgment.
That's why. That's how we remember.
I
the
was
case.
informed by the respondent's counsel
They have filed.
that they'll take 1 more week's time, but I don't see him in court.
Mark the presence learned senior counsel for the petitioner, none for respondent, despite opportunity being granted on 2/8/2023. Counter has not been filed on behalf of respondent. However, by way of indulgence, 10 days further time is granted to 2 weeks further time is granted. Counter filed.
No, they wanted to file an additional count. That's what.
Acha.
Your lordship,
No, then say
in item
delete them.
35.
Delete that. In pursuance of liberty granted on in terms of order dated 2/8/2023, the respondents have filed not counter.
In this matter, my lords, a counter has been filed by the government. I want a week's or 10 days time for filing a reply.
All right. A petition is admitted for hearing. Learned senior counsel for petitioner. Praise fund is granted 3 weeks time to enable him to file counsel.
Obliged.
Ah. Counter not filing. Who is not filing counter?
Second respondent, but I'm requesting time, requesting 2 weeks time for filing counter.
Last time also it was done. Why don't you file a counter? Oh, shall we, if he is not listening to you, then we have better way of calling him here and then he will respond.
2 weeks time, right, file counter.
Illegal mining is taking place.
Yes,
Learned counsel for
President,
the respond GP. Once again prays for adjournment to enable him to file counter by way of indulgence. 2 weeks time is granted to file counter. It is made clear in case counter is not filed on or before next date of hearing, appropriate order shall be passed.
Obliged.
I pay for respondent number.
We were about to dismiss it because 2nd August also you didn't appear. Good, good. Good. Yes.
May requested to take off the 2 weeks, we want to file a reply.
No, this is all SURFACE Act. We are bound by our view. Senior counsels of this court have been so fair that they don't argue and say that we be permitted to file an appeal under section 17. Mr. C, our view according to you may be erroneous. But we are bound by it. We have relied on Satyavati Tandon and latest judgment of Supreme Court to say that you avail of a remedy. We cannot take a different view in your case. Same bench. No chance. File an appeal. In this petition, petitioner has assailed the validity of the notice dated 29/2011. 11. Please see, madam, which date issued under section. Issued under the provisions of SURFACE Act. Full stop. Admittedly. Delete, madam. Order under section 14. No order passed. Correct. So before you are for the bank.
The respondent bank.
So they where is
It was also delivered to us.
delivered?
Yes, it has been executed and delivered. It was delivered.
When?
It was delivered to us at 4th at 11 o'clock.
4th what?
4/5/20. On 4th is May 20.
What to do? Yes. Then you should say no. Mark the presence in the with consent heard finally. In this petition, petitioner has challenged. AM, right?
The commissioner's report is there.
11:28 AM on so and so. Full stop. In view of aforesaid submission, you take recourse to whatever remedy, what can be done in view of aforesaid subsequent event challenge to notice dated so and so, since it has already been implemented, does not survive. However, liberty is reserved to the petitioner to take recourse to such remedy as may be available to him in law. With the aforesaid liberty, petition is disposed of. This all contract employees. Mr. What happened in SLP?
SLP numbered, my lord, SLP numbered, my lord, yet to be heard by Honorable Supreme Court.
Some date is given,
Date.
Mr. Kapoor.
Mr. Kapoor, some date is given in SLP.
Date is not given, my lord.
So when should we take it up? After 2 weeks?
2 weeks.
Lord,
May I have it after 4 weeks, my lord.
Okay. This
Because,
is good. Right. Yes.
39 to 48.
Learned counsel for the parties. In this petition, the petitioners who are the employees of who were employed on contract basis in the courts of special magistrate courts in the state of Telangana, seek a direction to
For
regularization of their services. Full stop. Admittedly, against an order dated 12/6/2000. Mr. Come at 2:30. Huh?
Item 116 to 121. The medical matters will have, for this will have the allotment is not the 116 to 121 may be taken about 230.
All right. So after we finish this, hardly any case. We'll take it up today.
With your lordship's kind permission, my lord.
Yes.
My friend from Advocate General from Andhra, my lord, Mr. Sriram is also before this court.
Yes.
In fact, my lord, sir, there is a matter which is listed before the Honorable Second Division Bench. My lord, sir, interpretation of section 50 and 51 of the Reorganization Act is involved in that matter. And when the matter is taken up, in fact, have opened the arguments. At the same time, my lord, we have informed the Honorable Division Bench. Since the roster, my lord, is allotted to your lordships, subject to your lordships, my lords, if some day is fixed, whether your lordships takes up that matter or.
So whether division bench has passed an order saying that it be listed before as per roster.
My lords, the division bench was pleased to place the file before your lordships, my lord. At the same time, we have requested.
We'll deal with it. What date?
Any date, my lord, subject to your lordship's convenience.
Yes. Any date in the first week of
He is available here. You have to tell us.
Lords, he's a good host and he's hospitable, and therefore whichever date he is comfortable.
And we believe it's a friendly fight.
Yes.
Yes.
And therefore, my lords, any date of your lordship.
We can't say anything. I will deal with the inform.
As your
You
lord.
tell the date, mister. Don't this thing.
Yes.
This issue can't
Any
be
days,
dealt with.
yes, my lord, sir. First week, my lord, any day subject to your lordship's convenience.
12/9.
Yes. Yes. And in case, my lords, the Special Standing Counsel for the Government of Andhra Pradesh requests the indulgence of a hybrid hearing, in case I can.
Whatever. That's facilities available. He can,
Correct.
everybody can avail of.
As read.
Yes.
Obliged, man.
Oh. Lakshmi. Ah, yes.
Matter will not say
Flood
that
victim.
may
Ah.
inform this court, but I'm supposed to file an affidavit on behalf of the respondents. Pending this lordship's order, subsequent to which about 23 families have been paid the amount. The rest of the families, some legal issue is pending. Otherwise, the government has released 4 lakhs per family, along with 1 lakh as towards Raitu Bandhu.
Last time, this week, 11th of August, we had filed.
Yes, and your lordship wanted to know, how many people are affected in flood victims. 20,387 people are affected.
So, number of persons identified as flood victims.
20,387 is the figure.
20,000.
387.
This is an additional figure.
Yes, sir. And apart from this, now everybody is returned to their homes, shelter.
And special measures taken under epidemic disease.
Yes, sir. This medical team has been deputed under ASHA workers and the Anganwadi teachers. They are helping them with the medical facilities. And doctors are also placed. And apart from this, out of 49 deaths which occurred, 23 people have been compensated with 4 lakhs amount.
1 minute.
Ex gratia.
So this ASHA workers are providing medicines.
But ASHA workers, NMAs and AWC teachers.
NMAs.
Yes, sir. Along with the medical team, they are providing it.
And third is
4 lakhs per person is paid to 23 families.
23. Of how many?
49 deaths. The ex gratia amount which is sanctioned, but they are ready to identify the legal heirs, the rest of the families.
So 26.
23 minutes.
No, remaining 26 not paid because
there is some legal issues, which but lordship may defer it till Monday.
Legal heirs not identified.
Till Monday, your lordship may defer. I'll put it in the affidavit format. I have informed my friend.
Correct, Mr. Prabhakar.
Monday.
Monday is right. We are having how many already? 74, 75.
About that any day convenient to my lord's minutes.
22nd. Tuesday we can have.
Obliged, but I'm deeply obliged.
So you want to file an affidavit?
Yes.
One more submission, Milad. Today morning also IMD has alerted Telangana, Milad. And 4 days heavy rains are there.
Yes.
From today.
Now I've also been in touch with the officers, in fact it's been indicated.
Publicate large, your lordship may direct.
From today till?
Today onwards to 4
Tomorrow,
days.
tomorrow onwards, I'm told.
Tomorrow onwards.
There's some likelihood of rains from tomorrow onwards.
Date.
Heavy rains are there.
Tomorrow.
The morning.
18th of
18th August till 22nd.
That specific date is not with me.
All right.
Till 21st. 21st.
Last.
All right.
18 to 20.
Yes.
Last time, where they are not
They will do
taking
it.
the precautions, 51 people are died.
What makes you believe that this time they won't take precaution? He's saying so.
Yes.
And we are,
But the 500 crores which was released, it is being allocated to Panchayat Raj and Roads and Buildings Department, to the various departments where the road repair works have also been undertaken. And I will put this.
So you want to place on record an affidavit?
Yes,
mark the presence. This court had issued additional directions to the state government on 11/8/2023, by which the learned special government pleader was asked to furnish the following details by way of an affidavit. Paragraph. Learned
14,000 minutes.
Ah,
But I just put it in the affidavit form. That,
we have noted it down.
yes, but earlier orders were not.
Okay.
14,216. 14,216 is what the earlier figure.
So that is additional number of how much? 6,000?
14,216 plus 100.
14,206.
But 6,000.
84
into
6,181. Thus, an additional number of 6,181 victims have been identified to whom the benefits due to them shall be extended. Number 2, it is further submitted, not number 2. It is further submitted that ASHA and NMS, whatever NMS, right, whole thing, are extending. We don't know.
So one more submission. ma'am.
Supposing if on that case, item number 1, you will argue till 4 o'clock, so what happens to 2:30? Flat victim. And so it will come up. We will take it up on Tuesday's 22nd, right?
One more submission. ma'am.
22nd August.
One more submission.
Tuesday.
One more submission. ma'am.
Please.
Actually, 51 were died, Milad, and 49 they are showing, Milad.
Ah.
And names also
If
have been.
You disclose, Mr. the names. You disclose the names on affidavit,
Yes, I have already-
place it on record, then we will obviously ask them.
I have already disclosed at page number 11, which has been submitted to him also on the last.
Please find out it's whether 49, 51.
I will find
out.
Of
Yes,
course.
where one is the graveyard keeper, one is woman Miller, and both were not mentioned in their names in the Kuppalapalli district.
He will check up. Right? There's no problem. This thing, there no issue. Right? Nobody is contesting this litigation, right?
I'm obliged.
Deeply obliged.
50. You want to file rejoinder? Counter they have filed probably.
Yes, ma'am. JHMC has filed its counter. Respondent number 1, 2, and 3.
One,
9 to 11, already filed counter 19.
1, 2, and 3 have already filed a counter. Respondent
No,
corporation.
no, who has not filed? We are not concerned with who has filed.
All of us have
Both respondent not filed well. Both respondents not filed.
So who appears for R4?
For B Nursing Board appear. B Narasimha.
He is not there. So obviously doesn't want to file counter. What?
Nursing Board I made it.
Then say so, madam, that I appear for respond number 4. I want time. He has not filed means we are, we think. Mr. Would you like to file rejoinder to this? File. Petition is admitted for hearing. Let counter if any on behalf of respondents who have not filed.
This matter and for respondents lordship, we filed counter today lordship.
Learned counsel for
Respondents lordship. We filed counter today lordship.
Only for the respondent number 3, counter has been filed this morning.
admitted for hearing. So and so submits that whatever counter shall be filed during the course of
Only
the
for
day.
respondent number 3, the counter has been filed. 1 and 2.
Respondent number 3.
1, 2, and 4 is.
Submits that R3 has filed the counter today.
Yes, Lord.
And
1, 2, and
counter, if any, on behalf of remaining respondents be filed within a period of the period of 4 weeks therefore.
Obliged, Lord. Yes, obliged.
Yes.
Notes on behalf of respondent number 2, 5, and 6. Today we filed counter claims.
Learned counsel for respondent numbers so 2, 5 and 6
Respondent number
submits that he has filed the counter today. A petition is admitted for hearing usage. Admitted so and so let counter if any on behalf of remaining respondents be filed within a further period of 4 weeks.
This Milad, I need to file the proof of service Milad. I'm waiting for reply.
Learned counsel for
Respondent number 3.
what is this PIL?
PIL
Appointment of a chairman, minimum wages authority.
Yes, Milad. Though he belongs to the ruling party, has appointed as chairman, Milad, which is contrary to the law.
Respondent number 1 filed counter also.
Learned counsel for the petitioner. The petitioner in this petition filed as public interest litigation has assailed the validity of GOMS dated 25/4/2023 by which respondent number 3 has been appointed as chairman of minimum wage board.
Yes.
Minimum wages board.
Yes, ma'am. Which is the section 9 of the law.
Learned counsel for the petitioner submits that the aforesaid GOMS right. Admitted for hearing. Say, madam, in the beginning. Admitted.
That's why I mean, in this matter, I'm for respondent number 3 minute. I already filed a affidavit minute that we have taken a demolition minute.
One of
Some portion of the
about what about 1 and 2?
1 and 2.
My lord, I am appearing for respondent number 2, my lord. I have not filed counter. I am accepted. With that.
Learned counsel for respondent number 3 submits that he has filed counter on.
Lordship.
When have you filed?
1/8.
1/8/2023. 1/8/2023. However, let counter if any on behalf of respondents 1 and 2 be filed within a further period of 4 weeks.
I bet them get. For the respondent. My lord,
What IA 1 of 23
my lord,
says?
against the
commercial court, commercial court appeal in 37, my lord. Whereby, my lord, your lordship recollects.
Yesterday I filed my counter and also synopsis also has been filed. Synopsis also has been filed.
List of dates I'm also given. Its only issue is regarding earlier the law was under, as laid on by division bench of this court, the aliens, my lord. So at that time, suit.
We'll take it up at the end of motion. And like if it can be really disposed of in 10 minutes or so, either side 5 minutes each.
Wait.
All. At the end of motion. So other should not wait.
I'm for the respondent in this matter.
I'm the appellant.
55 to 57, it's a batch.
Batch. Okay. Yes. 58.
There's slight urgency in this matter.
Your lordship fixed today, my lord.
What is? Synopsis there.
Yeah.
What is the impugned order?
The impugned order restrains the author.
Section 9.
No, it's not arbitration. This is Copyright Act.
Copyright. Okay. At the end, you have prepared a synopsis. We believe
everything is before your lordship.
At the end of motion, others should not wait. Also.
For R3.
Somebody wanted.
Item 59, 60, my lord, allotted to me because I am representing 50. My lord, I think today only my stuff, there's no way.
You want to file counter?
Counters file.
They have prepared and given to me.
Learned counsel for
The lordship, I am for the petitioner lordship. Continuously, small submission lordship, they are continuously taking the dates, your lordship. Since, yes, your lordship, respondent.
Did you hear?
You know the reason for the change of counsel?
Your lordship, in item number 59, Madam Uma Devi counsel was there in 59. In 60, it was changed.
You know the reason, no?
No,
You know the reason. Why
Sorry,
the counsel is changed.
no, your lordship. Yes, your lordship. In 60, aware, your lordship. But 59,
probably did not hear her say that counter is ready in her hands. She has filed color today or whatever got the file today. So therefore, she will finalize it and file it. So once the counter is in her hands, there is no reason to believe that she would not file it in 2 weeks. So your grievance stands redressed, right? Madam, you undertake to file counter within, that's what we will say. That's fine. Undertaking published to the court, if violated, madam knows what happens. Madam, if you don't file counter within 2 weeks, this is an undertaking. By way of last indulgence, learned counsel for respondents 1 and 2. Praise fund is granted 2 weeks time to enable her to file counter. It is made clear that in case counter is not filed on the next date of hearing, appropriate order shall be passed.
God bless.
My please, Lord.
61.
I filed my appearance yesterday, my lord.
No.
Lordship, kindly grant me 3 weeks time filing counter.
Learned counsel for respondent praise warrant is granted. Oh. To file counter, Mr.
Yes, madam.
You understand?
Yeah, I know that.
Same reason which
Yes,
brother was asking in previous case.
Yes, madam.
That's why he's here.
I know that.
Learned counsel for respondent praise warrant is granted. How much time, Mr.?
3 weeks time.
3 weeks time to enable him to file counter.
To file counter.
What's? We are not concerned, madam, when it is allotted, yesterday, day after, day before yesterday, this don't make anything to this. You want time, understandable. Don't say allotted to, how are we concerned? we are not responsible for allotment of this case to yesterday. We did not allot it to you. Then don't say this allotted, not allotted. It's a privileged communication between you and your client. Correct? Evidence Act. Evidence Act, 1872. Client and this thing. Don't disclose it by saying to everybody present here. So what you are trying to say that your client is negligent and that's why yesterday he gave that.
Not that one, my lord. I have entered my appearance only yesterday, my lord.
Learned counsel for respondent praise fund is granted 3 weeks time to enable him to file counters.
May I request a short? But may I request a short date, Manoj? There is a counter already filed. I'll file a reply. A short date, 2 weeks.
She says she wants to file counter. You say it's already filed.
Counter is filed.
Acha. Learned counsel for respondent. Huh? 63.
Today I filed counter lot in this case.
Yes. Not saying anything.
Lord, today I received a counter copy orders. We are ready to argue the matter, Your Lordship.
You want to file any reply?
Not required. We are ready for.
All right. No, you may be ready, but court should have time, right? Why a 23 litigant should be heard on that day and copy delivered at his residence? And why this gentleman 2000 waiting? See your senior here, left hand side, to your left side. He is waiting for 2000 writ appeal. The gentleman who's sitting with specs.
Much obliged.
His appeal is of 2000. He should wait.
Interim stay may be granted at least, Your Lordship. Interim stay may be granted, Your Lordship.
What? Merely because it's being.
Your Lordship, last time stated that 17th will be heard about the interim order, interim direction, Your Lordship.
All right. Petition is admitted for hearing. Counter on behalf of respondents have been filed. Counter to IA 1 of 23 for writ petition.
Main writ petition, sir.
Or counter to main writ petition has been filed on behalf of respondents to the main writ petition.
Counter has been filed, that filed the adoption memo in all the other cases has to be heard.
Yes. Yes, yes. You want to file any reply or something? Reply to the counter, nothing, not required.
Already made my submission, not earlier date of hearing. But I have to be reheard again because of this.
I don't think we have heard you. Yes, yes, yes.
Item 73, I am appearing here.
Petition
My
is
counter is-
Learned counsel for respondent submits that pleadings in the case are complete. Appeals are Admitted, these are appeals, right? Appeals are admitted for hearing.
Interim orders may be
Interim
extended.
order granted on earlier occasion shall continue. Open to everyone, whosoever wants to move an application for early hearing, we will deal with it. Yes.
Eight.
Early hearing or vacation of stay, Mr. GP, whatever. Whatever, whosoever. Vacating stay also you can see.
Lordship, in
We don't
item
know.
75, I'm for the petition, Your Honor.
Yes.
The petition has been filed challenging the constitutionality of Telangana municipality.
This,
Section 5.
I'll be, if
It's
you
all
can
these
get me. There is a judgment of Supreme Court as well as I am also author of judgment on in Karnataka High Court.
In fact,
You have that.
A similar petition was filed here. It was allowed. It was.
You have that order.
I don't have it right with me.
Find out.
No, it's pending before Supreme Court. It was allowed. Your Lordship.
So therefore the issue is, see, I would like to, because I remember,
Yes.
see why it is necessary, not because it's Karnataka High Court, but because I am the person who is common factor.
Yes.
So I have to see that I take a consistent view. Supposing if I've held something in Karnataka and you persuade me to take a different view, I should consciously do it, right?
Yes, yes.
Therefore, it's not that it has to be, you can convince still that whatever view has been taken, you can't take. This case is different, but you first place on record that order.
I'll place.
I've dealt with this. The issue involved in this writ petition pertains to right of elected members.
Yes, ex officio chairperson.
Ex officio members to vote for the post of chairpersons. The petitioner who is petitioners who are elected ward members of
Kukuda municipality. In fact, a similar petition was filed. It was allowed. Section 5 was read down, which has been now carried up to Supreme Court and stays there on that order. So until that is decided, this may not be.
Learned counsel for the petitioner fairly submits
fair.
that issue involved in this writ petition is pending adjudication before Honorable Supreme Court in
SLP 3988 of 2023.
Got it, madam. 3988 of 2023. He therefore submits that the that hearing of this writ petition be deferred till adjudication of until the SLP number so and so is decided. In view of aforesaid submission, hearing is adjourned sine die. However, learned counsel or for the parties are granted the liberty to mention the matter as and when the specially decided by Honorable the Supreme Court.
Obliged.
What happened to SLP? SLP 11/10/22. See your order.
Yes.
11/10.
Civil SLP is pending.
What happened to SLP? None for the appellate. Let none for the parties. A bench of this court by an order dated 11 a bench of this court by an order dated 11/10/2022 had taken note of that had taken note of the fact that against the order passed by a bench of this court on 6/3/2020 in WP 6165 bar 2018 as comma specially petition has been filed before Supreme Court, namely SLP civil number 11149 bar 2020, wherein the court has wherein the Honorable Supreme Court has granted stay of the order dated 6/3/2022. Full stop. What? In view of the aforesaid hearing is deferred.
In this case, appearing for GP for civil suppress, you could not. I request time for counter, filing counter your
Learned counsel for
GP for civil suppress.
Which respondent?
respondent number. You don't know. Court should find out, right? For whom he is appearing. Tell him. You also don't know. Learned counsel for respondent number 1, 2, 1 to 3. Praise warrant is granted 4 weeks time to enable him to file counter.
3 weeks.
Admitted for hearing. Huh? 80.
Wait, please. When the writ petition filed, the State Road Transport Corporation is the petitioner. Has filed this writ petition without questioning the continuation of arbitral proceedings in contravention of the mandate under Section 29A of the Arbitration and Conciliation Act. Going by the admitted dates and events in the case, the arbitral tribunal has lost its mandate.
Senior counsel, you will agree that this will have to be heard finally.
Yes.
It's worth admission.
Rashma indicate some date. Because by consent, earlier, we both agreed that we would request the arbitral tribunal not to proceed further with the matter and
There was one particular date, but if my laws are fixing a date, then I will further request the honorable tribunal to my laws. But my lord, the applicable positions are.
Please ask your colleague to prepare a synopsis and to help us move faster with this case.
We'll do so.
Otherwise, we will have to keep on noting this 1 hour will go.
We'll do so.
My lords, may I submit, my lords? This was already directed, my lords, and both sides have prepared those synopses, my lords.
Please give it to us. That's
Maybe
what
hand over, my lords.
Now, what we prepared earlier given was only a chronology of events, not a detailed synopsis of submissions.
So apart from the chronology, this thing you
will also prepare it.
One page submission,
submissions,
decisions. That's all.
Certainly,
we think you will be able to conclude very shortly.
We'll do so.
Learned senior counsel, they heard on the question of mark their presence in this writ petition, the relief in the facts of the case is not the same as saying that there is a statutory bar or constitutional bar in approaching the court, which we don't think. Perhaps your case is that in the facts of the case, whatever is, we don't know, they are not entitled to relief.
Article
226 does not bar that petition filed by KSRTC will not be entertained under Article 226. Which provision?
Certainly, my lords, only one particular aspect, my lords, in respect of Section 16 orders of the Arbitration Act, my lords,
The specific view taken by the Honorable Supreme Court, was in my respectful submission, is that if Section 16 is dismissed, the bill is
An application, we'll give a date. You can appear through video conferencing.
I'm grateful.
We'll fix a date.
Grateful, madam.
Eighty is done. 80. 81. Rejoinder.
May it be given. Hearing for on behalf of the petitioner.
That he's letting the student and extra information hard because of the situation of the whole practice center class. And he is approved the student this is where the implementation and no action is being taken. That is a municipal authority.
Who appears for municipal authorities? Your grievance is that you have made a representation on which no action is being taken. Who appears for municipal authorities?
Environment, the veterinary officer and district collector. 1, 2, 3. Who is supposed to take action?
4 is there, my lord. 4 is environmental engineer.
He is not taking action, right?
My lord, they have issued a notice. They have filed a report. Respondent
So
number.
despite service, nobody, this thing, pollution control board, nobody represents. Environmental engineer or pollution control board, you should say. Mr. Prasad.
Different by. I'll just instruct the. I apologize for the absence.
Mr. Harendra Prasad, learned senior counsel. Prays for short accommodation to enable him to seek instructions on behalf of pollution control board and to make a statement. And to seek instructions, that's all. 30th August 23. Mr. Prasad, the thing is that his grievance is that he is a owner of a some what hall? Function hall, and this respond number 5 is carrying on this poultry business due to which he is getting a stinking smell. And he has made a complaint to pollution control board.
I'm told a counter affidavit is filed by respondent number 4. From the Mr. Vishnuvardhan Reddy, counsel, I'll inform. That takes.
You will appear, right?
So take instruction.
We are fixed a date, right? What date? 30th August. It comes.
30th. Much obliged.
List on 3rd.
The similar matters, my lord, yesterday were posted to 13/7, 13/9, my lord.
I may be excused, me.
Pursuant to interim order, he was permitted to write.
Wow, 83.
81, my lord, I appear for the petitioner.
81.
81 is over.
81 is over, mister.
Yes.
Some council appeared.
No, I am for the petitioner. He is appearing for unofficial respondent.
I am for the respondent number 5 million.
You didn't hear the order. Tell him what is the order. No, that doesn't mean that you interrupt the court and ask what's the order.
I may be excused. Second week of September. Second week of September.
Senior was appearing, my lord, as per his convenience. Senior agrees to the date, my lord. I have no objection. But Leonard senior counsel was appearing for.
Mr. Prasad.
I'm for the respondent of 5 million. Second week.
You said that pollution control board 30th August we fixed.
Yes.
Now some other person has come. I don't know after.
Second
He
week.
woke up after the order was passed.
Actually, my client is not feeling well.
No. You have to argue, not your client. If he is not feeling well, that doesn't make a difference.
I may be excused.
Sir,
We have
nothing.
posted it to 30th August.
30th August.
No, come 30th August.
Order is passed, we will not change it. We don't. You don't have a friend in that the mark. Nobody in Hyderabad is your friend. Who can 30th August can inform that you are on a pilgrimage. Not fair. Would be a pass. Thank you. Yes, madam.
Item
83.
yesterday, similar matters were posted to 13/9, Pursuant to interim order, a petitioner was permitted to write a TJ examination.
So we'll find out what has happened. None for the petitioner. Learn it.
I appear for the petitioner, sorry, Mulad. I appear for the petitioner.
Yes, mark his presence. Similar, you have appeared in the examination, right? In pursuance of the interim order. In pursuance of interim order dated 20th July 2023, the petitioner has appeared in the examination for recruitment to the post of district judge held on 23rd and
22nd and 23rd.
22nd July and 23rd July 2023. Learned, you are what?
Respondent, second respondent, I'm appearing.
Learned.
Standing counsel for second.
Learned standing counsel for second respondent submits that the similar writ petitions have been posted for hearing on 13th September 2023 in view of aforesaid list this petition as well as on 13/9/23. Meanwhile, open to them. Before that you write. Meanwhile, it is open to respondents to file to counter if so advised.
Deeply obliged.
Obliged, Mulad.
I'm appearing for the response 2 and 3. Filed my counter minutes.
You have filed?
I have filed my counter minutes for the respondent number 3.
What about 1 and 2? Nobody wants to file? No, we are only asking who is want to file. Learned counsel for respondent 1 and 2 submits that he does not want to file counter. 1 submit that he does not want to file any counter. Learned counsel for respondent number 2 and 3 submits that he has filed counter.
I filed the counter for the respondent number 3.
Submit. So then 2 you don't want to file.
That's it. I'll seek some time alerts. The lordship may pass 2 weeks.
Mr. Either you should seek deletion of your name. We are telling you. Either you should seek deletion of your name. If you are a party, if you don't file counter, what are the consequences in law? We need not tell you. Standing here and telling that I don't want to file counter, he is chief secretary. Chief secretary doesn't mean that the law of this court does not apply to him or her. No, you are a government advocate representing, right? These proceedings are being live streamed. Your performance should be seen. And advocate general is present, right? So it's not on an invitation that we want you to file. Don't file. Be happy. We don't want the government to suffer on account of Mr. Advocate General. Please take care of this case. Tell your people, we have requested you earlier also but the message delivered by you has not reached him. First one day only we said that everybody is responding now. The situation is very much better than what it was 2 weeks ago. But the message has not reached him. So his old tactics adopting, standing up, looking at us.
I'm sorry, my lords.
No, you need not be sorry, but tell him.
Yes.
You mean, you know what we mean.
Yes,
right? We have nothing against him.
We'll advise that. Obliged.
Learned counsel for respondents number 1 and 2, pray for and have granted 4 weeks time to enable them to file count.
Matter, my lord, lordship may defer it by 4 weeks for a file counter.
85, madam.
85. Appointment of chairman to finance commission is the prayer.
Yes.
Last occasion on 12th June, my lords have directed the learned GP to get instructions as to
Probably
what time.
he wants to come with this thing.
My lord, last time
4
also
weeks
I
he
had
wants to come. A lighter weight, at least you can smile, right? There's nothing wrong in smiling at 3:30.
I'm smiling at him, but they don't smile at us. That is the problem.
No, he should.
Always serious.
He should see. He's smiling.
Yeah, for a change, for a change.
I always.
My lord, it is a simple thing.
Simple.
The government is required to constitute a state finance commission under the Constitution of
He's
India.
not denying it.
But they don't do it, my lord.
Some time, your lordship.
My lords may consider. Last time also, the same petitioner had to approach this honorable court, and this on the directions of this honorable court, a state finance commission was constituted for a period of 2 years. It came to an end, my lord, in the year 2020. Another commission would have come and gone, and even thereafter one more commission would have come and gone. But they have so many advisors. I don't know why those advisors do not advise on these things.
Yes, sir.
3 weeks. 4 weeks, I request.
No, but you have to last date also the time was granted to you
Proverbs.
to apprise this court within how much time the appointment shall be made.
But next date I'll inform it because I have also returned to the state. It's there on record. Lordship may defer it.
And this is what is the contention. It's a constitutional mandate.
Yes.
Which you have to fulfill.
Yes.
And you cannot, like, you have heard senior counsel is so much agitated that you are not even smiling at him, not doing anything and not smiling also. So you take care of him at 4:30.
4 weeks.
By offering him a cup of coffee in somewhere.
He's always.
So no,
They are very generous, my lord. That way they are very generous.
Generous.
They're very generous.
The Advocate General for lighter vein, the state of Andhra Pradesh was also before us appearing with
he was here, my
Advocate General for of Telangana. So he Advocate General for learned Advocate General for Andhra Pradesh also said that this Advocate General of Telangana is very good host.
We are known for the hospitality.
Hospital, yeah. Yes, yes.
My lord, he has never invited me so far. My lord.
But just now you said they are excellent hosts.
I said only generous.
Generous.
I have said only generous.
Mr. Advocate General, you should prove him wrong today itself.
Certainly, my lords, yes.
My prayer is, my lord,
yes, prayer is.
Lords may grant them time, but let them appoint within that time. Not that they'll come up again after 4 weeks and say that we want 2 months more to appoint. Instead, within 4 weeks, let them appoint. That would solve.
No, supposing if we allow the petition, right?
Yes,
today
because of
itself, no, allowed today itself, what they will do, travel northwards, then say that High Court should have been more considerate. Only on 15/6 notice was issued. We need some breathing time. That's not the issue. They are dealing with flood victims also, right?
There are no
providing treatment, basic facilities in government hospitals to citizens. So many things, right? You will understand.
In the alternative, may
3 weeks.
One small 2 weeks, my lord will say. Let them come up, my lord, as to how much time.
After 3 weeks, my lord, I'll report to my lords. So take instruction, report to my
2 weeks.
2 weeks.
2 weeks, your lordship may defer.
All right. Mark the presence, Mr. Harinder Prasad, learned. Definite thing, right?
Yes.
Ah.
I'm obliged.
The last occasion, notice of the right to be ordered, counter the right to be filed.
Respond number 4 and 5 filed the counter yesterday, which are filing a rejoinder. Respond number 1, 2, and 3.
For respondent number 1, my lords,
1 to 3.
My lords, for respondent number 1, my lord, I request 1 week time, my lord, the counter, my lord.
And
In fact,
but
2 and 3, I also request all right time.
1 week. Learned Advocate General.
4 and 5, let your file.
Yes. Mark everybody's present. Learned Advocate General for respond number 1 and Learned Senior Counsel for respond number 2 and 3. Submit that, pray for accommodation to enable them to file a counter. Let this be done within 1 week. Learned Counsel for petitioner. However, praise for it is granted. How much time?
I need 1 more week after that to file my rejoinder.
Shall file reply stroke rejoinder to the counters which may be filed on behalf of respondents within.
So that there are 35 minutes, so that they can get instructions. They make an allegation that respondent 4 and 5 were earlier defaulters, which is a false statement, Millets. That's what the HMDA may have to answer that. Yes, because if you are not defaulters, then you are.
We are sure senior counsel has taken note of your submission.
In fact, in similar circumstances, this honorable court was pleased to dismiss the application.
Let him file this thing.
Similar minutes. There are 10 minutes.
No, there is no interim order, right?
I am bringing to lordship notice that.
We'll consider not
settle.
Prepare a synopsis.
Yes, settle.
If you are in a hurry.
No.
No. We are asking everyone. Whoever wants to decide the case, to get the case decided in motion hearing must assess on facts. Yes.
Only request for a specific date to be given.
Why? It's a public interest litigation. You are not getting a contract of collection of toll.
I'm not asking for urgent, only a date, so that may be fixed so that on that.
It comes up this, see, Mr. We are in the process of introducing an auto dating system. In respect of, I take this opportunity to inform everyone, including President and Advocate General, that we are in the process of introducing auto dating. Mr. Advocate General, next week onwards, we are introducing a system of auto dating of cases.
Yes,
so whatever, like if we say 3 weeks, the matter comes up, it is a system generated date and it comes round about that time before the court and it will be listed, right?
Yes.
So don't this thing, once we say 3 weeks means for 3 years it won't come up. That apprehension don't have now.
Very well,
because that thing is taken care of.
Grateful, my lords. We are grateful.
Rating system we will introduce.
We will be very grateful of the lordship's millet. If auto generation of dates, copies millet, both are millet made available. Copies of the orders also made to the younger youngsters.
Order, is there any delay in supply?
My lord, you already.
How much time does it take?
It takes some time. There should be some procedure.
How much? No, we are, that issue also.
There is no court order millets. Now, if there is an order by the honorable court, they are giving. If there is no court order millets, it's taking some time millets.
How much?
1
you
week,
want to?
10 days, 15 days, 1 month.
Interim order also.
Sometimes interim order. Final order, it's taken time.
Final order.
1 week, 1 week. That's what interim order was 1 week.
No. See, this issue has also been put for circulation among honorable judges of this court. We have invited their views. This was a demand by the Bar Association, and therefore, like we had considered that it will be considered. So it's under active consideration. We'll come up with some sort of guideline and to see implementation part of it. How is it like? What's the difficulty? It's being examined.
Yes.
Millet, it is a taken up case, Millet. We have filed a counter.
Custodial death. Custodial death.
Alleged custodial death, but
and you have said that he died on account of cardiac arrest.
Yes, cardiopulmonary arrest. Even in under 176 inquest report, let the 10th Metropolitan Honorable 10th Metropolitan has reported.
Where do we get it? This thing medical.
Page number 66, Millet. In the inquest report submitted.
Mr. Additional Advocate General, the Honorable Supreme Court directed you to file a compliance report with regard to CCTVs.
Yes, my
Whether
lord.
that has been filed before the Honorable Supreme Court. On last occasion, I was at least informed that the state government, the state representative before the Honorable Supreme Court said there was some communication gap. And that is how it could not be filed and time was granted. Whether it has been filed with regard to CCTV footages, installation of CCTVs in all the police stations.
In this police station, particularly in this case, my lord.
It was
there
there,
is a
CCTV footage there.
Yes, it is there.
It is available.
Yes, my lord. It is available. In fact and indeed, we wanted to submit in the section. My lord, section written, this procedure is not permitting us to receive the CC footage. These are ready with us, my lord.
Ready with us.
Yes,
We
ready.
will have a look at it. And in the meanwhile, you submit about what is the status of installation of CCTV in all the police stations in the state.
I will. On that, my lord, I get instructions insofar as this case.
How much
my lord, I
time?
will.
Yes. How much time?
15 days. Subject, your honor.
Mark, of course, mark the issue which arises for consideration is this case.
Even went to the extent of holding, it's a law under Article 141. Well, for total status, I will
So
bring
you
at
are
least
not
50.
adverse to the idea of.
Yes, that's true. That's true. Well, that's
And this case, it's available, so we will look at it. Right?
Yes.
This case CCTV footage is available, right? This case it's available.
Right
no?
now available. Right now available.
We will see it on the next date of hearing. You give it to us. We will see it in our chambers or here if possible and then decide. But you tell us what is the status.
Yes. Next 15 days.
List after 3 weeks.
Much.
Old one, this person. This lady, these people waiting, right?
But that should be submitted STR before. What? Pen drive let.
Pen drive you produce on the next date of hearing before us, you hand it over to us. We will make arrangements to see.
Macho.
You go through this thing, CCTV footage first before showing it to us, right?
Yes.
So otherwise, if something appears, you will say, I am sorry, I didn't know what is being this thing, CCTV footage, right?
18 months they are now required to keep the storage. 18 months as per the direction. Madam, before you start, please look at the watch. Please try to concise yourself. Submissions we have heard for 1 hour.
1 hour, 20 minutes has been given to senior counsel, for this thing. He should not continue for another 1 year, 1 hour, and then say that it has been released. You don't leave any scope for the judges to decide, right? By arguing 1 hour, 20 minutes, we have heard him. We have understood what are the facts, everything. But reading everything, this will take years together. If he starts reading from first page in the High Court of Andhra Pradesh till the last, ask him to be concise, madam. We have understood. Others are also waiting, right? Two cases, senior counsels are waiting, but you are since waiting. Therefore, we thought that we should give this opportunity to conclude. Madam, 2 other senior counsels are also waiting in commercial appeals, which are urgent matters. But since you are waiting since Monday, we have given precedence. Make use of this opportunity and conclude within 50-20 minutes because
15-20 minutes.
not possible, then we will hear some other day, Saturday.
15-20 minutes. Some other days.
Have it on Saturday.
Huh?
Have it on Saturday.
How much will you argue, Mr.? What an extent?
Just
It may not.
Not prepared to conclude in 20 minutes, right?
It may not be over in 20 minutes. It is impossible.
Huh?
Lord, kindly have it
Madam,
on
this
Saturday.
is not seeking review. Please understand.
Have it on Saturday.
Not seeking review of law laid down by Honorable Supreme Court in Keshavanand Bharti. Not a matter to be considered by full bench of this court. Nothing of that sort. It's an ordinary litigation. We can only make a request. We can only make a request to the senior person appearing before us to conclude. Then that's why then don't blame courts by saying that I had argued. This is big in between these 2 your cases, which will not be concluded. We can decide 2 commercial appeals. That's better. You are not in a hurry as it is waiting since 2000. Wait for more years. What to do? This continues in the list. This will continue in the list. We are not adjourning. Madam, it's not being adjourned. It will come up tomorrow. But we will hear 2 commercial appeals which are urgent in nature because at least we will be able to pass an order. In your case, you say that you will not conclude. That means you will take 1 hour more. So it's not possible. Unproductive thing. Got it. We want to have it tomorrow.
Have it on Saturday.
No, we want to have it tomorrow also, but why?
Not be both.
Mostly your lordship will have important matters.
So this is also an important matter, madam, for us. But the problem is you are not prepared to conclude. 1 hour, 20 minutes is still on.
It will not be over.
Not in a position to.
You,
And,
madam, you should
if
have,
it-
least you could have done was, instead of sitting here, prepared a written submissions.
Written petition.
Then why are you arguing that?
Repetition is also there, my lord. Therefore, kindly have it on Saturday, my lord. My earnest request is to have it on Saturday.
We will not disturb the
Because it
list.
will not be over in 20 minutes.
Madam, we will not disturb the list. These cases will be called on Saturday, right? Even if you are not there tomorrow, no order adverse to you will be passed. It will be repeated on Saturday. And request, request him to be brief, madam. That's what we can request him to be brief. That's all. Request, you say that court is requesting him to be brief. Those days are gone. We don't have that kind of luxury to decide the second appeal in 2.5 days. Those days are gone, unfortunately. He is left behind in times, good old times. What can be done? This is reality.
Lord, we are giving the points of law. We are giving the decisions. The decisions which have not been cited, we are giving the.
We'll see it on Saturday.
Saturday. You said Saturday, right?
No, Lord, I could give the copies of judgments also. If you want. Saturday.
Taking up on Saturday.
No adverse. No adverse order.
Seeking an assurance from the court in writing also. Once we have told you that, see, madam, this is, have some pity on us. That, madam, we are saying that we will not take it up. So far as nobody has doubted the statement of the judges. The whole thing is, madam, whole thing is that if we say on Saturday, a order sheet has to be written, somebody is required to type it, we are required to sign it. Therefore, we are saying that we will take it up on 19/8. You don't rely on this, right? Fine. Learned counsel for the petitioner. Learned counsel for the petitioner prays for adjournment to enable him to prepare the case. Learned counsel for the petitioner, which case?
Yes, sir. Yeah, you are looking at it, 88.
This different list. 88, different list, right, madam? Learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same list on 19/8/2023. Not fair, madam. There's nothing to smile. We are not amused by this idea that when we told you that it will be taken up on 19/8, then despite that you are insisting for an order. Not fair. Not fair, madam. Not fair to the court.
I am not able to.
I don't hear.
I am not able to hear your lordship.
Good.
Because
these are the things which you shouldn't hear.
I have got some difficulty in hearing. I am not able to hear your lordship's observations. I will find out from my.
Find out. These are the things perhaps you should not hear. Focus on preparation of your case and point and conclude within as soon as possible. We have disconveyed our pleasure to madam that despite being told that it will be taken up on 19/8, she has insisted for a written order. Nothing, sorry, madam. We are not sitting here. You are not committed contempt. We are not exercising contempt jurisdiction. So you should not tender an apology. This is what least you should understand. Sorry.
Passing on matter item 18G Kalyan Chakravarti Rubaina is.
It is unable to hear.
Ma'am, first my apologies, morning I was not there.
This is something else, right?
No, but same matter, my lord. 9-2 not being compliant, your lordship wanted arbitration conclusion.
18. Yes, yes.
I-
Who had, yes.
No, my lord.
Oh, therefore you should stand up, right? So that we identify the submission made by you.
Exponent submission.
Yes. Yes.
As I said, my apologies, morning I was not.
No, it's all right. Yes.
My lord, two dates are important, my lord.
No, till today, the arbitration.
No, my lord, your lordship may take the counter. There is an order passed by Justice Ujjwal Goyan, as the lordship then was, appointing an arbitrator, tribunal entered reference. They are recused from that. The lordship would see the column on the counter, my lord.
Oh, because this is the only submission which was made by counsel for the appellant. You again, Mr. So that senior counsel knows.
Section 11.
No, please now argue so he is present because whatever is conveyed to him, what you have argued, there may be communication gap. Oh, that your colleague was there. She is standing there. So we said that the submission is enough to knock her down for the present. So you must state in his presence. Yes.
No, I have no.
This appeal is under August order dated 28/9/2022.
Yes, madam.
Where is that synopsis and all that you said? Again, we are back to writing.
The synopsis was in the other matter, madam.
Not in this one. So we have to no option but to write against what order 28/9/22.
I know your lordship, I have done Monday at Tuesday, we'll give the synopsis at your lordship. Well, it's a short point, my lord. I'll just, as a morning I said, it's a short point. It's still a short point in the afternoon as well.
Petition under Section 9 Arbitration Conciliation Act are partly allowed and you have been restrained from creating any third party interest.
Findings, findings in my favor, order against me.
Oh, this is a, I'm reminded of one of the councils in my home state, Madhya Pradesh, Jabalpur. He used to argue, tell every judge, all the findings in my favor, judgment is against me. So judge would naturally go through the order with wrapped this thing, all details and very attention that how is it that all findings in your favor and this thing.
Subject to
lighter when agreement agreement is dated.
When your turn comes, sir.
Agreement dated.
Agreement is dated 21/9/2010.
21/9/2010.
I am not a party to that agreement. It's a memorandum of understanding. And it is memorandum of understanding and it's titled as leave and license. My lord, admittedly, as per the agreement, the duration of the agreement was until 2019.
What date?
21 September 2019. The agreement expires by 21 September 2019.
Yes.
Under the agreement, it was an agreement to lease. It's not a lease, but an agreement to lease.
This MOU is agreement to lease.
Agreement to lease.
Then what happened?
Subsequently, the person with whom the Section 9 petitioner entered into this agreement, he sold the property to me. That property was a subject.
One of the parties to MOU sold the property.
One of the parties to party sold the property to me.
Which responded?
The appellant here, man. The appellant in this case.
Appellant has sold to you.
The respondent number 2 has sold to the appellant. When?
Sold to the appellant. Which Property in question, we can say
I'm sorry,
property in question, or does it need details? What is the property?
it's immovable property.
What is residential complex? No.
No, it was meant to be a
Land.
commercial theater. It was meant to be constructed as a commercial theater.
So immobile, some construction. So,
Yeah, it is property.
Then when it was sold to you?
It was sold to the appellant on 25/7/2019.
Then what happened?
My lord, he has then now the for appointment of arbitrator. It's
He
very
means-
important, my lord.
Again, he means R1.
I'm
So
so
you
sorry.
should give us,
Not
he means R1, G
R1.
means R2.
R1 filed an application. I should be precise.
This is what your colleagues standing by your side should have done it, Mr.
R1.
Troubling us with writing all dates. He was passing on, give it.
List of dates.
Why should we deprive? We have to state the facts. Why did you prevent him?
I thought in his turn he could do it.
No. He is only referring to facts.
I was only assessing
This
the
all,
document.
then submissions, of course, you have to make. You can go through this. Anything date is wrong, please tell us that this is wrong, incorrect, something. This gives details, right? This
Well,
which you. You didn't tell us that 13/2/2017 fire NOC was obtained.
Because that's not relevant to the.
Hey, lighter, you can at least smile at 4 o'clock, Mister. What is there? Huh? At least you can. So you didn't tell us that 13th February is an important date. NOC, fire NOC, negotiate. Yes.
In the trial court, in the section 9 order.
So he filed this thing, petition under section 9 and 27, then 12/3/21. He filed a petition under section
9.
11, sorry. 11. 11.
12/3/2021 is a section 11.
Section 11, right. Yes. Then
kindly see the section 11 application filed by page 86 of the counter filed by.
so this whole issue has been dealt with, right? The parties who are not, you are saying that I am not a party. That issue has also been dealt with. We think chloro control has been clarified later on by Supreme Court, right?
So let me summarize my.
You said that I am not a party. That means this section 9 is void order because I am not a party.
Lordship may take it both ways. Let's assume for a second, my lord, that.
No. We are just trying to understand, right? Whatever you said. Please go ahead in your own way.
My lord, my first proposition is that.
So then what happened, section 11 thing?
Section 11, an arbitrator was appointed.
When?
25/4/2022.
All right. Then.
And my lord, then the final impugned order came on 28/9/2022.
28(9).
The final impugned, section 9 impugned order.
Yes.
These are the facts, my lord.
Yes.
My lord, my first proposition is that, as your lordships in the morning have shown, section 9 subclause 2. Section 9 subclause 2, Arbitration Act.
Conciliation Act. Yes.
Section 9 subclause 2 states that if you obtain an interim order against a party, you must commence arbitration proceedings within 90 days. Section 9 sub.
Yes.
Yeah, section 9, my lord, I'll just read it, my lord. Where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1. The arbitral proceedings shall be commenced within a period of 90 days from the date of such order, within such further time as the court may determine. In this case, it was the section 9 petitioner and the respondent here. His case before the arbitrator was that even though the appellant is not a party to the MOU, he subsequently stepped into the shoes of that party, and therefore he is bound by the MOU, and consequently I'm entitled to relief under section 9 against him. That's his case. So, my lord, the short point is that when he himself is contending that I have stepped into the shoes of the party with whom he has entered in the MOU, then he must commence arbitration proceedings against me by filing a section 11 application. In the section 11 application, which I will show to your lordships, I am not arrayed as a respondent.
Section 9 contended that appellant has stepped into the shoes of That's why, Mr. Senior, you are here, no? You are a local or you are a Delhi person?
I'm Hyderabad.
Hyderabad. So then always better save time of the court. When we said 5 minutes, this issue is not that big. But these submissions one by one, what you could have asked youngsters to prepare your proposition, dictated them to them. 1, 2, 3, 4. Case law at the bottom, paragraph so and so. Within 3 minutes it would have concluded. Now this thing, your submissions we are required to note down. Wish we had done the shorthand course, so could have been faster, but not so.
I'll ensure that it doesn't repeat.
Contended that appellant has stepped in shoes of respondent number 1.
Respondent number 1. Respondent number 2, my lord.
Respondent number 2. And therefore,
he should have, under section 9(2), he should have commenced arbitration proceedings against me.
First submission is section 9. He contended that you have stepped into the shoes of R2, and therefore he is entitled to interim measure against
me. So, my lord, if that submission is correct.
Which paragraph of the petition?
In section 9 petition at page.
Para
33 at page 44.
Para 33, 44 of the paper book. This. Right. Then, however, in section 11, you are not implemented.
I'm not made as a part.
Which page, section 11?
Counter at page 86.
No, 11.
Yes.
11 he has filed. No?
11 he has filed. At page 86.
Along with counter.
Counter.
At page 86, appellant not implemented.
Appellant not implemented.
Yes.
And my lord, he filed the section 11 as it's evident from the.
So, and the third is obviously that arbitration proceeding against you not commence 90 days.
As in commence 90 days. So it all crystallizes to one point, my lord, which is that having obtained a section 9 order against me.
Arbitration against appellant not commenced within 90 days of ad interim order.
And 90 days of ad interim order and 90 days of the final order also.
Not commenced. Not commenced either from date of what is ad interim order?
Added model date, my lord, is 27,
2019.
it's a 28/12/2019.
And final order dated
28/9/2022. So it's 90 days has expired.
So that you relied on that which judgment
Karnataka High Court judgment. Where Karnataka High Court said that if section 9(2) is not complied, it automatically gets vacated.
That's it.
But this is where, my lord, I said the finding is in my favor, but the operative portion is
against you.
The impugned order.
His brother is saying something.
I'm sorry.
You should hear.
Operation successful,
Patient dead man.
Yes.
So in the impugned order, the learned judge, I contest that I'm not a party to the agreement. The learned judge rejects my submission and holds that no, you're a party to the agreement by incorporation. So in other words, the categorical finding has been given that I'm a party to the agreement.
So what are you doing? I mean, you have been restrained from creating third party
rights.
You want to create third party interest.
But I'm a subsequent purchaser. I am not bound. I'm not a party to the arbitral process.
So these are the submissions, right, Mr.
Sorry, I didn't hear you.
So which we have noted down, these are your submissions.
Yes, ma'am. And my second point.
So the arbitration proceeding has not initiated for you within a period of 90 days. Therefore, the order stands vacated in view of division bench judgment of order of the or judgment of the Karnataka High Court. This is number one. Second is that in this thing, though he is taking contradictory stance in the sense that in a petition under section 9, he says that you have succeeded respondent number 2, and therefore he is entitled to seek an injunction against you, yet he does not impede you in proceeding under section 11, right?
And third, my lord.
And third, you are not party to the agreement.
And the third, my lord, the final.
No, if the first this thing succeeds, everything else need not be answered, right?
Exactly.
First, the order does not survive beyond 90 days, then nothing.
And my lord, since Lordship is hearing it finally, I'll just make 2 submissions on the remaining points.
Finally, you said that it is to be heard, or who said? I don't know. You said.
No, I'm only saying.
On your insistence, Mr. Senior Counsel.
At my request.
At my request, your request, and last time this is happening. Without synopsis, you are getting through an order like this, right? From us. Now, henceforth, your colleague should remember.
We will give it
synopsis and this thing. It's not our job to, because you want, we should hear it and write everything.
No, my lord, it's unfair on my part to
ask. Take care. We are sure that you will take care. This thing is giving it emphasis is only to ensure that not you, these people, youngsters, standing who are nodding their head, you can't see them, we are seeing their reaction. So that's why we are telling them rather than you. Yes.
Message recorded.
Yes, correct.
Malad,
yes. So what 2 more points?
Malad, kindly see the agreement in question. At page 59 of my paper book. Para 6.
Agreement dated. The agreement is MOU, right?
MOU. 21st September 2010.
21st September 2010. Which clause?
Clause 6.
Yes. What does it say?
It says the total tenure of the agreement is 18 years, but the initial tenure of the agreement is for a period of 9 years, which can be renewed. So,
total tenure of agreement is 18 years.
But the initial period is 9 years. The initial period is 9 years, which can be renewed. It is the admitted case of both parties.
Initial period 9 years, which can be reduced.
Which can be renewed. Admitted case of both parties that it was not renewed.
or can be extended also, right?
So the
It
agreement,
can be reduced or it can be extended.
it can be extended, but it was not renewed or extended. But
Not reduced.
not renewed. So the agreement concluded by 2019. 2019, September 2019. So my proposition, my lord, is that when, and the learned trial judge rightly gives a finding, well, the learned trial judge rightly gives a finding that the agreement has expired and it is not a concluded contract. Once the contract is no longer in existence, a Section 9 order cannot be given to enforce the terms of that contract.
Contract is not in existence, then no application under Section 9.
Section 9 can be made.
Yes, anything else?
And it's a determinable agreement, my lord. It's a, as a lordship knows,
Any
it's a
case law apart from this?
my lord, I'll just give one hand over the Supreme Court Judge percepting. It's Section 9 cannot be given for a determinable agreement. Please. Para 59, man.
Para
59 and 60. 60 is my emphasis. So but in this case, the contract was for only for a period of 3 years. After the 3-year period, what's compensation?
What does it say, Mr. Para 59 and 60? We decipher something else than what you are saying. Therefore, read Para 59 and 60.
59 is for the principle that if it cannot be adequately compensated.
Therefore, if it can be adequately compensated, injunction should not be granted.
That's one matter. 60 is for a different principle. We have perused the contract in detail. The terms of the contract were expressly limited to 3 years from so-and-so to so-and-so, unless extended by mutual agreement. And all obligations and services under the contract were to be performed during that term. And the next para they give
in your case, same for this thing, till 9 years and all terms to be performed during 9 years.
So Section 9 was filed. Your Lordship got it. That's exact.
It doesn't have that 90. And say it can be renewed for further term.
Yes. So where is the finding that after expiration of period, no Section 9 can be entertained?
Next para, Section 60, para 61, last sentence. Class item F.
Yes.
However, the moment it is sought to be enforced beyond the term and expiry of the agreement, it becomes prima facie void as rightly held by the division. This is a Section 9 case. That's it.
So this is Section 9, right?
This is Section 9. This case is also a Section 9 case.
2006-4.
2006-4 SEC. Ultimately, my lord, this is a leave and license, my lord. It's a license agreement. There can't be specific performance of a license agreement. This is it, man. I'm grateful. I'll not ensure that the Lordship is not troubled the next time, I'll give a synopsis. My Lordship have heard my friend on the facts. 9 years or 18 years have to be reckoned from the date of completion of the building, not from the date of MOU. My Lord, it is.
You are appealing for?
For the respondent, my Lord, who was a petitioner in the trial.
No, there are.
Respondent number 1. I'm appealing for respondent number 1. My Lord, the respondent number 2 and in the present appeal, who were the respondent 1 and 5, were the owners and developers of a property, commercial property. They were coming up with 5 screens in that multiplex, my Lord. 5 screens of multiplex. So, my Lord, an MOU was entered, whereby after the completion of construction, my Lord, then we have to start the multiplex of 5 screens. The name of Cinemax, then it went to PVR, now, my Lord, now it has become Inox. But we have to have a right of 18 years of running the screens, my Lord, after completion. So, the date to be reckoned is not from the date of entering the MOU. It is 18 years or 9 years, as the case may be, from the date of they getting an occupancy certificate. That is not yet to be, 9 years is also not yet over.
Where is that?
My Lord, Lordship may come to page number 57 is the MOU, my Lord. That your Lordship can from 6.
57.
Page 57, the MOU, my Lord. Your Lordship can decipher this and infer from this MOU itself, my Lord.
Yes.
Now, my Lord, your Lordship would come to page 59, clause 6. The total tenure would be 18 years, page 59, my Lord. Clause 6. Total tenure would be 18 years. The initial tenure of this agreement will be for a period of 9 years, which can be renewed at the discretion of Cinemax for a further period of 9 years on the same terms and conditions. Not from this date. It only says 9 years and 18 years. And it has to be read along with clause 9, rent-free period. So from the date of aforesaid notice, that notice has to be notice, section 8, clause 8, notice to fit out. The owner developer shall issue a call notice of 30 days before handing over possession to Cinemax, and the same needs to be accepted by Cinemax in writing. At time of handing over, the owner developer shall obtain the necessary fire clearances, occupancy, partial completion certificate, or such a approval which are mandatory for the construction of a cinema theatre with 5 screens. The expected date for such notice should be March 2011. Then 8. The date of aforesaid rent notice, a rent-free period of 120 days shall be provided to Cinemax for the purpose of carrying out the fit-out in the said premises, and to commence the said business an additional 60 days to complete the licensing work for Cinemax. Normally, till today, that occupant, that letter itself is not given. So, the 9 years period is not even kicked in. So, therefore, the condition of my friend that 9 years has to be reckoned from 2010, therefore 9 years has come to an end in 2019. Therefore, I am trying to enforce my contract beyond 9 years is not correct. The light of 6 and 9.
Clause 11.
Clause. Lordship may come to clause delay in possession for carrying out of fit-out periods. If the owner developer does not hand over said premises, lift, ramps as per date mentioned in the clause 8, and such delay continues for more than 3 months, then Cinemax shall have the right, that's my perspective, have a right to terminate this MOU by giving 30 days notice, and further Cinemax shall be entitled to get refund of security deposit paid to the owner developer within 7 days from the expiry of the said 30 days notice, with interest to be computed from the date of payment till the receipt of payment at the rate of 15%. If Cinemax decides to exercise this, then this right, then till the NOC received from Cinemax, developer cannot negotiate or enter into the contract of lease for the premises. I did not exercise, but I am continuing with that contract. The Lordship would notice the termination clause also. It is only I have a right to terminate. They don't have a right to terminate. So I did not exercise my right of termination. I want to run my theatres there. It is only the right conferred upon Cinemax. Now, therefore, the first
which clause termination?
Termination is clause number 23, page number 62.
All right.
Now, your Lordship will notice only I have a right to terminate, not the developer or the one. No, but that's the first thing. Number 9 years has not started at all. Well, even assuming for 9 years, well, still the contract is enforceable. That's first thing. Second is, my Lord, my friend's contention was one of the contention is within 90 days, I have not initiated arbitration. But if the 9 to, if your Lordship sees that even the, both the judgment of Karnataka High Court, Division Bench, my Lord, if I don't initiate the arbitration after obtaining an ex parte order within 90 days, the interim order stands vacated. Ex parte interim order stands vacated. 9-2. But today the appeal before Lordship is not against the ex parte interim order. It is against the contested order.
It is not against the ex parte order. So both the Karnataka High Court judgments are against the interim orders, ex parte interim orders.
But section 9 itself is the interim measure.
So 90, remember I am saying, ad interim order granted there. If within 90 days thereafter, you also may come to section 9(2), my lord.
So she can start, then they have to go to 70.